I mentioned one original segment.
No. Original side. Second half.
That was acquired by the irrigation department without notification. Matter is pending since 2019. The matter heard in the court of the Honorable Justice Supra Court. Later on, the matter is transferred to court number 2. Now, the matter already
Who is for the state? State, they have filed their affidavits or reports?
5 minutes.
Notice. Wait. Notice दिए Notice of mentioning given? You are given a notice?
May I be permitted to mention one matter for inclusion? For inclusion, it's a 2014 matter.
Yes, inclusion of?
Inclusion of motion. It's a motion matter, my lord. It's a 2014 matter.
Yes, microphone থেকে চলছে না?
It is a 2014 matter, my lord.
What is the
For inclusion, my lord.
Down list.
Chamber application for inclusion.
Second half. Second half. Second half.
Item number 1.
কোনো কাগজ আছে? Yes.
But your lordship wanted me to recapitulate, my lord. So your lordship will kindly take my written notes of argument, my lord.
Yes.
My lord, first 5 pages are the, my lord, nature of the proceedings and the reliefs in the writ petition. Your lordship will kindly come to page number 6, my lord. Paragraph 2. My lord, now, may I please, my lord? By a lease executed on 23rd February 1984, the respondent number 5 was inducted as a lessee in respect of an area measuring such and such at the first and second floor of premises number 18 Rabindra Sarni, Kolkata 7,01,000 for a period of 16 years. Well, this is with regard to how my predecessor in interest were the owners of this property, how they were inducted in the property, my lord. This is with regard to that. This was by way of a lease of deed of lease, my lord. Now, if your lordship kindly comes to paragraph number 3. Over the passage of time, Poddar Udyog Limited became the owner of premises number 18 Rabindra Sarni, including the demise premises. Well, then thereafter, paragraph 5. The lease in respect of the demise premises was due to expire on 31st March 1996. Well, thereafter, if your lordship kindly comes to paragraph 6. Yes. On 14th March, my lord, this is just before the expiry of the lease, my lord. On 14th March 1996, the state of West Bengal requisitioned the demise premises by an order bearing number such and such. The state directed to place the said premises at disposal of the land acquisition collector, my lord. My lord, this is how the land acquisition collector comes in. A notice is issued under the Requisition Act, my lord, and that is how. My lord, paragraph 7 now. My lord, now from here the litigation starts. So, my lord, this Poddar Udyog Limited filed a writ before this honorable court, my lord, that this is an illegal order. Requisition could not have been done. By my third line, paragraph number 7. By an order dated 24th December 2001, the honorable court was pleased to set aside the said order of requisition dated 14th March 1996, and the state of West Bengal was directed to quit and vacate the premises within 2 months. Now, what is important here is, my lord, this order of requisition is set aside. So, once this order of requisition is set aside, the land acquisition collector has no jurisdiction in the matter, my lord. he will only have jurisdictions when the property is vested or when the property is acquired, my lord, under the provisions of the acts, my lord, whether it is acquisition or acquisition. So he loses complete jurisdiction. My lord, in the meantime, what happens is, my lord, now if your lordship kindly takes paragraph 8. In the meantime, my lord, since this property is owned by a common family, my lord, that is Poddar, my lord. So, my lord, three companies go in for amalgamation. They come up for amalgamation before this honorable court, my lord. Paragraph 8. Meanwhile, an application under section 391, 392, 394 of the Companies Act was filed for sanction of scheme of arrangement between Poddar Udyog Limited, Poddar Projects Limited, Hope Cardamom Estates Limited, and Maharshi Commerce Limited, which is the present petitioner before your lordship, my lord. On 10th June 1998, the said scheme was sanctioned by this honorable court. My lord, this is very important. This honorable court sanctioned this scheme. It became operational, my lord. I will show that also. My lord, I have mentioned the page numbers, my lord, where it is mentioned, my lord. And my lord, the said scheme became binding with effect from 1st April 1996. Kindly see, my lord, this is there in the order of the sanction, my lord. So, my lord, the property, Poddar Udyog, the property comes to me from Poddar, part and portion of the property. It is divided among the other owners, my lord. Now, therefore, if your lordship kindly comes to paragraph 11, my lord, then the rest of the paragraphs are with regard to the areas and other things. Paragraph 11.
Before we proceed, who was respondent number 5?
My lord, respondent number 5 is, my lord.
He was the tenant under the erstwhile owner.
Yes, my lord. The property was given to Urban Development Department, my lord.
Okay.
Subsequently, what they did was, my lord, government amongst themselves, they transferred it to the respondent number 6, transportation planning, internal arrangement between them, government one wing to the other wing, my lord. Presently, respondent number 6 is in occupation, my lord.
This is transport department.
Transport department, my lord. Now, if your lordship kindly takes paragraph 11 at page 9.
Yes.
In the scheme, in part 3 at page 129 of the petition, it is clearly mentioned that from transfer date, inter alia PCI shall pursuant to section 394(2) of that and without any further act or deed be transferred to and vest and be deemed to have been transferred to and vested in Maharshi. So, my lord, this is transferred to Maharshi, my lord. Now, if your lordship kindly takes, my lord, paragraph 14, my lord. In the meantime, what had happened, my lord? This order of December 2001, my lord, which was passed setting aside the order of requisition, was appealed against. Initially there was an order of stay. And in the meantime, my lord, this appeal was dismissed for default, which none of the parties knew, my lord. So that is why, my lord, we had filed a writ and this order was passed go before the acquisition collector, because all these proceedings were happening under a wrong impression, my lord. None of the parties pointed it out before this honorable court that this order of stay is no more there, my lord.
Okay.
Now, if your lordship kindly comes to, my lord, paragraph 15. Meanwhile, on 21st November 2002, the state of West Bengal de-requisitioned the premises, accepting an area of approximately 4,449 square feet on the first floor. On 27 June 2003, the de-requisition portion was vacated and handed over. As such, the balance area of 4,409 square feet owned by the petitioner, which forms part of the area of 9,062 square feet, is still under illegal occupation of the state of West Bengal. The ownership of the said area by the petitioner is not disputed by Poddar Udyog Limited and Poddar Projects Limited. It is pertinent to mention that Poddar Projects Limited and Poddar Udyog Limited issued a declaration stating that they do not have any right, title or interest over the area of 9062 square feet, which solely belongs to Maharshi Commerce Limited. My lord, may I just show these two pages, my lord, 214, 215. Now the state is saying that no, Poddar Udyog Limited is the owner. They fail to consider the scheme of amalgamation. They don't take into consideration the order of this honorable court. 214, 215. There is no dispute to my title by any third person or any person, my lord. This is a declaration given by Poddar Project Limited at 214. Under the scheme, this is the area which was divided amongst the parties. they clearly say, my lord, if your lordship, may I just read this? We hereby declare and state that the total area of 37,062 square feet, which was let out to Calcutta Metropolitan Planning Organization as per the scheme of arrangement sanctioned by the Honorable High Court at Calcutta in company application number such and such, has been apportioned amongst the following owners as such. Your lordship will kindly see Maharishi Commerce Limited, 9,062. So 4,449 square feet which they are holding is from this 9,062 square feet. Calcutta Metropolitan Planning Organization has vacated an area of 19,036 square feet, and physical possession of the same has been taken over by us, which now entirely to Poddar Projects Limited. We do not have any right, title, or interest over the area of 9,062 square feet, which solely belongs to Maharishi Commerce Limited. A similar declaration given by Poddar Udyog Limited.
Yes.
So, my lord, they are saying that Poddar Udyog Limited is the owner. Scheme of sanction is very clear. Poddar Udyog Limited is also not contesting, nor is it claiming any adverse title to mine, my lord. They are saying that we have nothing to do in the matter. Now, if your lordship kindly sees, now pursuant to this, my lord, hearings take place before the land acquisition collector. My lord, with deepest of respect, all of this is a nullity, my lord, because the land acquisition collector cannot have jurisdiction over the matter, because this property is not vested under the act. It has not been requisitioned. That requisition has been set aside. I had also relied on a judgment of my lord, Honorable Justice Rohinton Nariman. I'll again place it before lordship, that the jurisdiction can only come when it is under the process of requisition. When the act does not apply, so the authority will not have jurisdiction automatically.
But then this point was not
My lord,
argued.
that is, yes, my lord. That is, I would say, my lord, that is a fault on our part also, fault on their part. Nobody pointed it out before the Honorable Court that the appeal was dismissed, my lord. So everyone was moving under the impression that the appeal is pending. So therefore, the land acquisition collector has jurisdiction, my lord. Now, my lord, thereafter, if your lordship kindly takes paragraph 24, my lord, 25. Land acquisition collector, he passes an order, my lord. In this order, what he says is, first he raises the issue of mutation, that we have not been able to show that the property has been mutated in our name. First of all, my lord, it is on facts I have shown, I'll again point it out, it is a false finding. Mutation is also in my name, and in any event, mutation is not, my lord, the evidence of title. If I buy a property, I don't get it mutated, it does not mean I do not obtain title. Mutation is only in the records of the corporation to enable the corporation to realize the tax, nothing else. And my lord, law is settled on this, High Court, Supreme Court, on this aspect. Second, my lord, they say that on one hand, they say that apart from scheme of amalgamation, we have not been able to provide any other document in respect of our title. My lord, nothing else is required. I have shown, my lord, the 86 judgment of the Honorable Supreme Court, a scheme of amalgamation. My lord, it is a judgment in rem. So on the basis of that document, that property has come to me. It's a scheme between the companies, and that has been sanctioned. And they've refused to follow that, my lord. They refuse to follow that. They refuse to take into account, which is completely illegal. First of all, he does not have jurisdiction. Even if he has, my lord, the order is faulty on these two grounds. Lordship will kindly take paragraph 26, my lord, in this. The impugned order suffers from non-application of mind and non-consideration of relevant materials on record. The respondent number 4 has not dealt with the order of scheme of amalgamation dated 10th June 1998, passed by the Honorable High Court at Calcutta, and has ignored the same which is binding in rem. Then I rely on this judgment. The respondent number 4 has opined that the petitioner did not get the property mutated in its name. It is a settled law that mutation is not the proof of title, and in any event, the mutation certificate was filed with the respondent number 4, as would be evident from the letter dated 24th March 2011 at pages 209 and 210 of the petition. I have also filed that. In spite of that, they say that complete non-application of mind, my lord. My lord, then this is the law, my lord. I'll again place those judgments. 27. In view of the aforementioned facts and circumstances, the instant writ petition has been filed by the petitioner inter alia challenging the impugned order dated 24th June 2011 and inter alia for seeking direction on the respondents to hand over the premises of 4,449 square feet to the petitioner and to release the rent compensation to the petitioner in the manner as mentioned in the petition. The said petition has been filed on the grounds stated as given herein below. It is respectfully submitted that the Honorable Court by its order dated 24th December 2001 already set aside the order of requisition and directed the respondents to hand over physical possession of the demised premises. The state of West Bengal has failed to comply with the same and is in occupation of the demised premises illegally without any authority of law and in violation of Article 300A of the Constitution of India. The respondents, apart from handing over the possession of the demised premises to the petitioner, forthwith are liable to compensate the petitioner. The petitioner relies in the judgments reported in such and such. Well, these are the judgments I have relied upon, my lord. The petitioner most humbly prays that this honorable court may be pleased to appoint a special officer in terms of the order dated 24th December 2001 with a direction to take physical possession of the balance area of the demised premises from the respondent and hand over the same to the petitioner. My lord, now then thereafter at paragraph my lord 29, the petitioner further claims a direction upon the respondent number 4 to forthwith give particulars. My lord, he is the land acquisition collector, respondent number 4. Forthwith give particulars of the amount deposited by the respondent numbers 5 and 6 and make payment of occupation charge deposited by the respondent number 5 and 6 in lieu of the rent compensation and deposit the same before the learned Registrar General of this honorable court. Petitioner further claims for the appointment of a competent person. Well, this is in terms of the judgment of the Honorable Supreme Court. Justice, well, what had happened, I'll place that judgment once again. Appoint a competent person as an arbitrator to determine the compensation that is payable by way of damages for occupation of the demised premises from September 97 and pass such award within 2 months from the date of appointment and pass consequential orders in the case the respondents do not agree for appointment of arbitrator in terms of the ratio laid down by the Honorable Supreme Court in the matter of such and such. Now, my lord, may I just show the document? My lord, then thereafter we filed a supplementary affidavit, my lord. I will just place that supplementary affidavit. My lord, now the question is, in the event I succeed, since this requisition has already been set aside by this Honorable Court in 2001, so the entire period of occupation by the state is illegal, my lord. Supreme Court has held, my lord, that if it is illegal, I am entitled to compensation. So now the next question arises is the mode and manner of computation of the compensation. Well, by way of the supplementary deed, my lord, I have annexed in that same premises, on the very same floor, there is a registered lease with a bank, my lord. My lord, this is at page 5 of this supplementary. My lord, this is the best evidence which I can place before your lordship, my lord. Central
Are the
Bank,
transport department depositing any rent?
my lord, they have given pursuant to your lordship's direction. Till date, they are giving rent at the rate of depositing it at the rate of rupees 10 per square feet, 40,000 a month. And they have given a, my lord, report also with regard to this. My lord, around 1 crore has been, my lord, deposited with the land acquisition collector, my lord.
Apart from that, you are also entitled, you claim that you are
Yes, my lord,
entitled to
because,
compensation.
yes, because from the period since their, my lord, occupation is illegal, I am claiming from that period, my lord, I am entitled to that as per the judgment of the Honorable Supreme Court. Now, if your lordship kindly sees this, my lord, this is the best document and this is the best evidence which I could get, my lord. Now, if your lordship kindly takes page 6 of my supplementary, page 5, my lord, deed of deeds. It was executed on 2nd day of December 2015. Well, this is to assist your lordship, my lord, as to what, my lord, and entirely it is up to your lordship then, my lord. Between Poddar Projects Limited, a company within the meaning of the Companies Act, having its registered office at 18 Rabindra Sarani, 9th floor, such and such, and Central Bank of India, my lord, having its head office at such and such. Now, if your lordship kindly sees last paragraph of this page number 6, my lord. And whereas the lessee needs a suitable premises for its banking business at its branch at 18 Rabindra Sarani, the business include besides systems and procedure of traditional banking. So, my lord, this is in respect of 18 Rabindra Sarani. Now, if your lordship kindly takes the last paragraph at page 7.
Hmm.
And whereas the lessee has applied to the lessor for a lease of all that space measuring 1,716 square feet, being portion of first floor of 18 Rabindra Sarni, Kolkata 7,01,000, being a part of the premises described in the schedule, which is a part in after unless and distinguished for the brevity called the demised premises, for a term of 21 years with 6 options of renewal after expiry of every 3 years. Well, then there's an increment clause of 15% after every 3 years. And this is apart from the corporation rates and taxes, which is mentioned, my lord, if your lordship kindly takes page 8. The lessee doth hereby, last paragraph, my lord, 1A, covenants with the lessor as follows: to pay the lessor rent for the demised premises at the rate of 120 per square feet per month for the total area of 1716 square feet from first day of October, regularly every month with 15% rise of the same during 6 options period of 3 years. Service tax is separate, my lord. Then if your lordship kindly takes paragraph B, to pay the lessor over and above the monthly lease rent as per clause number such and such, municipal tax at the rate of such and such, 20.25% being 50% of the municipal tax and commercial surcharge at the rate of 20% being 100% on the amount of rent. Well, this is the best evidence I could produce before your lordship as to what is the market rate in that area. My lord, apart from this, I have mentioned one more document. My lord, if your lordship kindly takes page number, my lord, 14. So 2 agreements I have annexed. One is the latest, and this one was in with effect from 2014, 120 rupees. My lord, this is an agreement for leave and license between the petitioner at page 14, my lord. This is an agreement for leave and license made on this 18th day of August 2023 between Marshi Commerce Limited and Subashi Freight Carriers LLP, my lord. Now, they have taken about 200 square feet, my lord, which is mentioned in the second paragraph on the ground floor, my lord. And now, if your lordship kindly comes to, my lord, paragraph 2 at page 16, the terms and conditions are mentioned. My lord, this is 60,000 rupees per month, my lord. Poddar Court, my lord, it is very commonly known in Kolkata, my lord. It is at the central hub, in central Calcutta, my lord. It's a very commercial area and prime commercial area of Kolkata, my lord. 60,000 for 200 square feet. This comes to 300 rupees a square feet, my lord. Well, this is the importance of that area and the rent, rate of rent, my lord, presently, my lord. Now, what the report which they have submitted, if your lordship kindly sees. Now, the best part is they give an opposition to this supplementary affidavit. Your lordship will kindly take this opposition once. Your lordship will kindly come at page 3, paragraph 7 of this opposition
Opposition
to the supplementary affidavit, my lord. This is
supplementary opposition.
27th June 2024, my lord. Performed by Mr. Subodh Kumar Roy.
Supplementary recent দিয়েছে।
It's a very short opposition, my lord, 5-6 page. 27th June 2024. They had filed it day before yesterday, my lord. Affidavit in opposition by the respondent number 4, 27th June.
Oh yes, it is. Okay. Yes.
Now, paragraph 7 at page 3, my lord. With reference to the statements made in paragraph 3 of the said affidavit, I say that the lease deed produced by the petitioner entered into by and between Poddar Projects Limited and Central Bank of India dated 2nd December 2015 has no manner of applicability in the facts and circumstances of the present case. In the instant case, the entire first floor and second floor of the subject premises, that is 18 Ramendra Sarni, had been requisitioned by the state of West Bengal, which was subsequently de-requisitioned except 4,000 square feet on the first floor, which is presently being used by the Transport Planning and Traffic Engineering Directorate. Hence, the said lease deed is not at all relevant in the facts and circumstances of the present case. And they are not in a position to dispute my valuation. What they say is, this has no relevance. Whereas this is the best deed which has relevance because this compares the rate in the same premises on the same floor. Well, I don't know, I fail to understand, subject to correction. How come this deed has no relevance, my lord? And they failed to deal with this. They could have said, no, the rate is not 120. As mentioned there, the rate is rupees 60. And this is what we are giving as a supporting document on our behalf. Nothing, no evidence. Only, and they rely that this department is an occupation which is illegal occupation. Then, same reason given for the other deed, my lord, at page number 8. There has to be a legal basis to counter my valuation. There is no counter to my valuation, my lord.
I think you are claiming your compensation from 1997.
1997. Because the
These documents are of 2015 and the recent one.
yes, recent one, my lord. My lord, then it is your lordship's discretion, my lord. But at least from 2014, I can show that this is the rate, my lord. Because this is the best evidence in respect of the same very premises. And what they are paying me is, till date, I'm not even paying me, but depositing with the land acquisition collector 10 rupees a month, square feet. Whereas the rate today, and this rate of 120 was in 2014. Presently, it is around 175, my lord, with the increments and everything. And I've shown on the ground floor, it is 300. The escalation is very high. It is, the area is very important. And I'm getting 10 rupees, my lord. Why I produce this evidence before lordship is, my lord, because I will place the judgment of the Honorable Supreme Court. Now, in these types of cases, my lord, when there is any dispute with regard to adjudication, the Honorable Court has two ways, my lord. Either it directs that both of you agree, appoint an arbitrator who will decide this. If it does not, if the, because it cannot be thrust upon any of the parties, arbitration has to be by way of consent of the parties. If not done, my lord, then court has the jurisdiction to do that. My lord, but before doing that, there must be some evidence, my lord, before the court, my lord. So therefore, I filed the supplementary in case they do not agree for an arbitration, as the Honorable Supreme Court did. Justice Rohington Nariman's judgment is there. In that judgment, the Honorable Court passed a direction that if they do not agree for arbitration, this is the rate I'm fixing. And that was fixed at 100 rupees a square feet, my lord. 2020, I'll place that judgment. Now, I will only place their opposition. What is their case, my lord? They have till date not been able to show as to how they can refute my title and what is the basis of their occupation. Well, they are simply trespassers. So first of all, they must show whether they are legally entitled to be in possession or not. Well, nothing. Now, if your lordship kindly takes the opposition.
Yes.
And if your lordship kindly comes to page 4, paragraph 4, my lord. Roman 4, my lord. Well, on 3, he has already filed a report. He is depositing this amount, and this is the old figure, so I'm not placing it before lordship. Till date, it is about 1 crore which they have deposited with the land acquisition collector. Well, page 4, Roman 4. The petitioner failed to produce the valid documents in support of his claim of ownership in premises in question. On the other hand, he filed a writ petition under Article 226 of the Constitution of India before the Honorable High Court at Calcutta by suppressing the fact that he is not able to produce the valid documents, that is title and mutation certificate in his name from the Kolkata Municipal Corporation as asked by the first land acquisition collector in support of his claim. Your Lordship will kindly pause here for a moment. Your Lordship will kindly take the what the land acquisition collector say.
Page number?
Page number 270. Approximation. और आप एक बार जरूरत है आप ये
Yes.
17 if you got it. Well, may I place this, my lord? This is important. Second paragraph of this. In compliance of the Honorable High Court as Honorable High Court Commissioner of the case, the tenant of the premise, all concerned were served with notice and the memo number such and such, requesting them to appear before the first land acquisition collector, Kolkata, on such and such. On the appointed date, I heard the representative of the petitioner, such and such, in the presence of such and such administrative officer of the transportation department and other officers of this office. Shri Tulsian produced a Xerox copy of scheme of arrangement sanctioned by the High Court by order dated 10th June 1998, company petition number such and such, connected with company application number such and such. I examined the document and advised him to produce more documents like mutation certificate issued by Kolkata Municipal Corporation in support of its clear title, the right and title of the petitioner of the premises in question number, question by 25th March 2011. And here they say that we could not produce anything. And over here, the land acquisition collector says, yes, they have produced this, but I have asked them for more title. And more title, scheme of amalgamation sanctioned by the Honorable High Court is there. He wants a mutation certificate of the corporation to decide over the Honorable High Court, my lord. Complete non-application of mine, my lord. Whereas this mutation certificate has also been given. It is on record, my lord. I will show that. Then what he says, I have examined the document and advised him to this place. Next paragraph. The petitioner was again served with a notice under memo number such and such to appear before me with the document in support of clear right and title of the petitioner of the premises in question. At the time of hearing, he pleaded his inability to produce any mutation certificate issued by the Kolkata Municipal Corporation or any other document except the scheme of arrangement by the High Court by an order dated such and such. There an absolute title of the said premises. However, he claimed the ownership of the property premises on the strength of the scheme of arrangement sanctioned by the High Court by an order dated such and such, and he argued that the petitioner is the owner of 9062 square feet of the said premises in terms of the scheme of arrangement. He also claimed that the requisition premises number 18, having more or less 4,449 square feet on the first floor, is comprised and included in 9062 square feet as shown in the scheme of arrangement. As per the office records, this premises has a checkered history. Well, it has no checkered history. According to him, in his mind, it has a checkered history. It may briefly be stated in proper perspective. The floor area of 37,062 square feet on the first and second floor of premise number such and such was requisitioned under such and such. Subsequently, in compliance of the order passed by the Honorable High Court on 16th June, of the four states of to cover each court of the premises in question. This is put on as per the requisition order number 6. Consequent upon the requisition, only 4,000 square feet was left over under requisition of the government for occupation of transport department. Of the first floor of the premises. What is unusual and surprising is that even after coming into force of scheme of arrangement sanctioned by Honorable High Court and Honorable High Court on 10th June 1998, the respective parties and more particularly the petitioner, for reasons best known to them, did not care to get their names related to them. Now that certificate is at 219, page 219, which was placed first. They ignored this also. And it is the next page. By way of a forwarding letter, my lord, all these documents were provided. Your lordship will kindly see towards the bottom. Last, Maharishi Commerce Limited. So his finding is also incorrect that the property has not been mutated, although this is not at all a relevant question of right. They have not bothered to the property has been transferred. vital document to establish one's claim as the lawful owner of any property. My lord, this is contrary to the law. My lord. The law says it is not at all a requirement.
এটা বলুন একটু আস্তে কথা বলতেন। Yes, yes, Mr. Sarkar.
Moreover, there is no documentary evidence to suggest that the said property has been transferred, deleted, or encumbered in any manner in the intervening period. What is the no other documentation is also was solely taken over by the property scheme of arrangement has been very much towards since 10th June 1998 as being by the petition. So it is evidently in contravention to the contents of the scheme of arrangement that Mrs. Poddar would be permitted to allow the possession of the possession premises of 33,006, which is in excess of had there been strict adherence to this scheme of arrangement, Poddar Udyog Limited would have taken over the possession only in respect of its own portion of 8964 square feet, and not the portion belonging to the petitioner and the other party as well as this evidently demonstrates that the positive scheme of arrangement has not been acted upon and made by the parties to the scheme of arrangement at the time of taking delivery of possession of the acquisition of the premises. Well, what they mean here is when this property, the balance, apart from this 4,449 square feet was given to one person went to take on behalf of all. And he was a representative of Poddar Udyog Limited. So they say that only one person gave. Well, this is internal amongst us.
Yes.
They say that the scheme has not been acted upon, whereas a certificate has been issued by the other companies. Well, after careful consideration of the prayer of the petitioner, submitted in writing in his representation and also presented verbally at the time of hearing, and also after examination of the documents and produced by the petitioner and relevant office records, I am constrained to hold that the petitioner will be able to substantiate his claim as the absolute owner of the suit portion of the premises in question. Therefore, he is not entitled to any rent and or other amount payable as the owner of the premises in question in absence of any valid document. Hence, I reject the application of rent exclusively in favor of market also for the said this order is, my lord, completely, my lord, illegal. It fails to take into consideration the right created by the scheme of amalgamation. He says, get the mutation certificate, that will decide your title. Now, if your lordship kindly comes to their opposition. Page 5, my lord, first line, suppressing the fact that he is not able to produce the valid documents, that is title and mutation certificate in his name from the Kolkata Municipal Corporation as asked by the first land acquisition collector in support of his claim number such and such. The wrong, complete false statement, my lord. That the said writ petition appeared. Well, I can skip this, my lord. Then if your lordship kindly. Well, this is how we filed a writ and the order was passed, my lord, but this was all subsequently under a wrong notion, my lord. My lord, now if your lordship kindly comes to page 7 of this opposition.
Yes.
The petitioner was pleaded his inability to produce any mutation certificate, irrelevant, although my lord I produced this, by the Kolkata Municipal Corporation or any other document except the scheme of arrangement by the Honorable High Court by an order dated such and such. So, my lord, according to them, this order means nothing, my lord. This is how he proceeds, my lord. Paragraph, my lord, Roman 8, that neither the new petitioner nor his representative submits the documents, that is the title and mutation certificate from the Kolkata Municipal Corporation, and fail to substantiate his claim as the owner of the suit portion of the premises in question, in spite of giving sufficient opportunity to submit the same. Well, again, they repeat, the only stand is, you are not the owner, scheme of amalgamation, they don't deal with. They don't say, yes, under the scheme, you are not a party, nothing has been allotted to you. They don't say that, but they say, they conveniently, they just ignore it. And they ask for mutation certificate. Well, then that is again repeated. We ask them to produce mutation certificate, and then if your lordship kindly comes to page 12. Now, how they decide page 12, if your lordship kindly sees the second paragraph, last 5 lines. Now, they sit and decide whether this scheme has been implemented or not, my lord. Even a party cannot say it has not been implemented. An order of court, a judgment of court when passed, it is not a choice of a party that we will implement it or we will not implement it. It is by operation of law implemented, my lord. And it is nobody's case, either of Poddar Udyog or Poddar project, that the scheme has not been implemented, or neither of the two go and raise an objection before the acquisition collector that, look, don't pass this order, don't give him anything, as we have not implemented this. On his own, he decides, last 5 lines. This evidently demonstrates that the purported scheme of arrangement has not been acted upon and adhered to in the letter and spirit by parties to the scheme of arrangement at the time of making delivery of possession of 33,062 square feet of the de-requisition portion of the premises in question for reasons best known to them. But he sits over as an appellate authority. You can't, my lord. Scheme, order passed, binding in rem, my lord, 86 judgment. Nobody can say it is not binding now. And best is none of the parties say. He says it has not been implemented. Who has no authority to go into this? Well, this is the only point they have in their opposition. Now the judgments, my lord, which I had relied upon. Kindly take, my lord, this judgment of 2021-14 Supreme Court cases 528. Kunal or Paper Mills Limited, my lord. Now, my lord, in this judgment, the Honorable Supreme Court has observed that. Can you give me a That's not the issue. Lordship, kindly come to paragraph 25 of this judgment at page 546. Yes. My lord, in this matter, what had happened is the requisition was over. 25 years had gone by since the order of requisition. So it lapses, my lord, after 25 years. So a point was raised that once it lapses and the act is not in force, as in the particular facts of the case, the land acquisition collector has no jurisdiction. Because if the act is not applicable, the jurisdiction of land acquisition collector cannot come. The Honorable Supreme Court has said, yes, there is force in this argument. 25. Coming to the appeals filed by the appellants, he said appeals are only on a limited ground, namely that the compensation for the illegal occupation of the premises cannot be assessed by the district judge under section 11(1)(b) of the West Bengal Requisition Act, as section 11(1) refers to compensation during the period of requisition and not after the property continues to remain with the state without any authority of law, even after the requisition period ends. Section 11(1) of the West Bengal Requisition Act reads as follows. Rather than this act is placed, a cursory reading of the aforesaid provision will make it clear that the appellant is correct in its submission, which is therefore accepted, and the impugned division judgment of the division bench is set aside to that extent. Well, in this case, what had happened is the matter was remanded back with regard to compensation before the land acquisition collector. The court said, no, if the act does not apply, it can't be done. Your Lordship will kindly see what the Honorable Court does after this. Paragraph 27, my lord. A very disturbing feature of these appeals in the fact of is the fact that WBMTDCL, which is state within the meaning of Article 12 of the Constitution of India, has continued in unlawful possession of the premises since 15/8/1998 without paying a single pice towards compensation till date. following the judgments of this court, most notably such and such, we appoint Shri Soumitra Pal, retired judge, High Court of Kolkata, as arbitrator to determine compensation that is payable by way of damages for occupation of the premises without any authority of law. A written authority to appoint such arbitrator is to be furnished to us immediately, that is within a week from such and such. If not so furnished, WBM TTCL will be liable to pay a sum of rupees 100 per square feet per month, being the average of the rental amounts paid by the other tenants in the same building since August 1998, as per the valuation report dated such and such, prepared by such and such chartered engineer commissioner, for the entire period of illegal occupation of the premises within 4 months from the date of this judgment. Next, 28. If the written authority for appointment of the arbitrator is received within the time, the learned arbitrator is to proceed on a prima facie view of the case submitted to him by the parties and determine the interim compensation payable within a period of 2 months of entering upon reference. This is owing to the fact that not a single price has been paid for the last 22 years for the illegal occupation of the premises. Further, neither party is to take any adjournment before the arbitrator, my lord. Then all this is. Well, I am in similar case, my lord. I am in fact in a worse case, my lord. It is now more or less 30 years. It is coming up to, my lord. So, my lord, it is clear land acquisition collector has no jurisdiction in the matter. They have no authority to remain in possession. Requisition which they had applied for was set aside by this honorable court, and they must return the land immediately along with the compensation. And one more thing, my lord, they have filed a report in which they have stated, my lord, that this amount of money around 14/5/2024, pursuant to your lordship's direction, my lord, they said, well, a single page document was provided. An instruction from the office of the first land acquisition collector, 14/5/2024. Well, may I just read this out for your lordship? With reference to the above, this is to inform you that present rupees 94,85,336 is lying with PL, account of first land acquisition collector, as rent compensation in connection with premises number such and such. And then your lordship wanted them to file an affidavit on my submission, my lord. My lord, then they filed an affidavit. The second affidavit, my lord. One is the opposition, and the second affidavit which they have filed is here, my lord. Now, if your lordship kindly takes paragraph 7 of this affidavit. Hence, the rent composition would be rupees 40,000 per month, rupees 10 per square feet per month, to and from outstanding from 27th June 2003, taking into account the monthly rent of rupees 40,000 per month, with effect from 27th June till 31st March 2024, which is about 49 months, 4 days. The rent compensation comes to about 99,65,000. A statement, they have an excess statement. Amala 2003 is their internal arrangement, because one department to the other department, it was handed over. But we are not concerned with that, my lord. That is an internal arrangement amongst themselves. We are entitled to a compensation from 1997, my lord, from September.
Okay.
And my lord,
Transport department has been inducted on 27 June 2003.
sometime in 2003, my lord. Because what had happened is, yes, my lord, because what they did was, from they handed over the requisition property portion of it, and they made an office of some other department. So that is their internal arrangement, my lord. And therefore, my lord, I am claiming compensation on the basis, my lord, of the report, which on the basis of the lease deed and the other evidence which has been filed with the lordship, my lord, from September 1997, along with the interest, my lord. And as directed by the Honorable Supreme Court in this judgment, my lord, 2020. My lord, these are my respectful submissions.
Yes.
Last order, 17 feet. With the cup as indicated in the total paragraph. The statement of the identity correct. Stating all the cup. Page 5 and 6. Page 5 and 6. Star 1. Since 2003 till March 2024. 99 lakhs Spencer thereafter.
Yes.
Based out of the copy. The aspect to order passed by Justice Paul is on 84 of the false order.
Yes.
Yes, the petition is disposed of by directing the past below. After giving up time of hearing is displayed of the grade and order shall deal with the same in the event in it shall issue appropriate direction. Yes,
Yes.
then whether that is the statement A to R to also. Other part comes third part by the all the what second paragraph also can in compliance of the order of the owner of the case, tenant of the premises and all concerned was served Please have done memo number 24. Appear to first part appointed as hard sanctioned by the High Court by an order. Examine the document. I think more documents. Vital more documents. As if they written from the order passed by justice, passed by this court, that relevant, some relevant documents. And it will has been sanctioned by properly. I examine the document and advise the more document like use as a certificate issued by the right for actions of but at the time of hearing, specifically noted the inability to produce any mutual certificate issued by the Kolkata Municipal Corporation. Now he said that mutual certificate already done. Why he has not produced at the time of hearing?
Hmm?
That annexure logic kindly see page 209. If mutual granted on 9th August 2010 in favor of the petitioner, he ought to have produced on them. He state was state the inability to produce. Now he said that everything was produced.
Page 29.
For the night.
Second one. The office of the first land acquisition officer receives the mutation certificate at the time of hearing, asks the petitioner to produce that. So what did you receive? Why? It was in your office.
In the hearing, it is recorded.
No.
Inability.
How the first land acquisition can ask him to produce the document which has already been submitted before it?
Difficult to produce another time.
No, he didn't say so. He didn't say that this has been submitted, has been misplaced. I asked the petitioner to produce another copy of the mutation certificate. He says that he is unable to produce that, and the office record says that it has already been submitted.
Inability. They are not.
I don't understand what is inability. The copy was with the record of the first land acquisition officer, page 209. So the officer who was cessation of the matter has the records which contained the copy of the mutation certificate. There was no question to ask the petitioner to produce another copy. Had it been the case that he has recorded that this has been furnished but misplaced, you place another document, another copy of the mutation certificate, it would have been a different case. Then,
No question, he also stated that I have already deposited the paper.
this is the wrong recording.
Question inability has not arrived. It is his statement. Petitioner statement. Not first statement. It is his statement. Because main thing was he has not produced any certificate. He has to produce because they first they are that immediately produce their paper or a compact before they will definitely release the entire amount to the original owner. It is the order of the owner. And of the regarding which are dealing with I think is that that entire prayer portion is all time compensation, only one prayer. Please hand over the land. Why? Because Lordship kindly see that my ABD operation, my non-request of that paragraph, it is in terms of the division bench order. Yes, the order passed by Justice Gupta. This is the order of ABI. This is the order. Yes, see.
Which order?
Minus
Page 3 of
page 2, Lordship Power for every document. Every document 5/1/10. That's 2014. Nothing but 2014. About something.
yes.
Minus page 2. What about the division? That is the commission order. What your or the order is. Yes, the order of the honorable division bench of Calcutta. That's the Gupta. If they go on to one, they can take pictures that portion of the property without prejudice to the rights that rights of property. The property owner of property land and transport for survey. First, second, third, yeah, but that's second subject. This was restored the owner of the road to permit square feet was handed over to transport department to file the copy. Surveyor and control. That's the one thing. Very good. What the flame 32 lakh now it is down about it. Put the measure that suppressed by Yes, that is global.
Nineteen of
I do not read it. This was 6 days, occupying the such range composition is sanctioned from the by was range composition on the body of which takes the of the officer is the check dated 2020. Last year I have already spent. Trespassers does not and cannot have
Illegal occupier.
another.
He says illegal occupier. There is no question of trespassing. You are in illegal occupation of the said premises that is alleged by the petition.
First order. My subdivision is ordered very quickly. It was correct. Both people. Direct, direct petition. To go before them and to do their job. Okay. So, popular is they are already. They matter, I think. That is their case. Or say they have to work. Cannot say. At least they cannot say. Because they are after the call order on order. That was not complied with by the department. If my lord was pleased to direct the department to comply within certain time, that is not. That's next order. And I just want
Yes.
page 184. I think that is not.
Yes.
Degrees of another order of class. That is page 196. 190. 2011 order.
Hmm. Yes.
It appears to tell you the paragraph 200. It appears paragraph 2 of the order from it appears from page 60. The demand was raised for of the file that filed on 19 February 2008. That is after about 5 years. Issue of delay in raising the claim, no order is passed of the refusal with regard to payment of the question of delinquency. There is a liberty to file a representation before the past it is a 4 it is 4 from the date. If the defendant filed that same respondent shall dispose of the same by passing a order. Notice can be time.
The requisition has already been held. There you go.
No. You can follow the order. Lord, you can extend the order.
The property de-requisition has already been done. So there is no question.
That is in respect of 37, but out of this entire issue, this writ petition is with regard to 4,449.
4,449
Yes.
is included within 37062.
My lord,
Yes.
yes.
So de-requisition is already done by the notification dated 3460.
My lord.
Huh?
My lord.
Now there is a family arrangement between the parties. They say that you have failed to produce any documents, so you are not entitled to that. This is the case. So why are you harping on de-requisition and extension of time? This is not required because GA 4474 order is passed by the Honorable Chief Justice for direction for de-requisition. That has been done. Okay. Next.
That perfect to my order, I have updated my calculation. And I think I am only adding that no question of the other thing. Here, I just so please directly authority. Australia. Consider a place. Consider a place. If my lord chooses to enhance the individual loss, I am not standing the either for advertising article or the collector will fix the rate. That is the 78. Only rate is
But what about your position?
position is concerned with the position here. Just to initiate another position, not in a deep petition. You cannot get that there with
Okay. Yes.
Not the Bena and past knowledge to the petition.
Yes. Can you reply?
Your lordship will kindly take the order of Justice Secretary my lord at page 101. Well, yes, I will show the principles, my lord. Your lordship will kindly see this order.
I am all the three of United States dollars. Which I not by the individual.
So there is no merger when the appeal is dismissed, my lord. First principle of law. I will come to that also. They are relying on an interim order of the appeal court when the appeal is dismissed. My lord, I fail to understand this proposition law, my lord. I will address your lordship on that, my lord. Lordship kindly sees, my lord. 109, my lord, of Order of Justice Kalyan Jyoti Sengur. My lord, from where my right to file the writ has come. Therefore, I set aside the order of requisition dated such and such. Accordingly, I appoint Mr. Ramesh Sharma of Bar Africa, practicing advocate as special officer, who shall take symbolic possession forthwith. He shall be paid initial manner. Then is the question of remuneration. Thereafter be reimbursed. I grant time for a period of 2 months to vacate and quit the property. Failing which, the special officer shall take all steps with police for taking physical possession of the said property. No matter the question of filing a rate or not filing a rate or filing some other proceeding is over. This order has attained finality. They preferred an appeal. An interim order was passed in that matter. And then the appeal stood dismissed. Now, my learned friend has showed the interim order to your lordship. But when the appeal is dismissed, whether the interim order can have any force. Secondly, my lord, in the interim order, what the Honorable Appeal Court has held, if they want, they can give away the property. It is a voluntary act on their part. So out of 37,000 and odd square feet, they have held back 4,449 square feet. which according to this judgment of Justice Sengupta, they are bound to return to us, my lord. I need not file any other separate proceeding, my lord. This order is already there, my lord, and no SLP preferred against the order of or no recalling, review, nothing filed before the Honorable Division Bench. My right stands crystallized, my lord, and the entire derequisition process is illegal. That is also established, my lord.
What is the number of that appeal?
My lord,
Which
the
was
number,
dismissed?
My lord,
Order of dismissal has been annexed.
my lord, paragraph, my lord, this is APO number 43 of 2002 and APO number 130 of 2002.
Orders have been annexed. Orders.
Orders are not there. It is pleaded in paragraph 10-11. In their opposition, they have admitted, not disputed. And they should have disclosed before the land acquisition collector. Look, my appeal is that it has been dismissed. They suppress this fact.
Paragraph numbers.
My lord, paragraph number 10 and 11. And your lordship will kindly see how they deal with this in their opposition. It is admitted. And they should have gone before the land acquisition collector or before the writ court that yes, we had filed this appeal, it has been dismissed. They have suppressed this. My lord, my right stands crystallized. This order of Justice Sengupta, appeal is dismissed, my lord. They have not preferred a SLP. They have not filed any review, my lord. This order stands.
I'm coming to an answer.
Now,
I think some misunderstanding.
second, my lord. Second, my lord. My learned friend has argued that some more documents were required. My lord, it is a wrong finding. Either he has to specify which document he wants more. Some more documents is like he will say you did not get a birth certificate, you did not get a school living certificate, will not do, my lord. What some other document which he thinks is relevant? It is a vague finding, my lord. And the documents have been submitted to him, my lord. In spite of that, some other documents. This is like, my lord, when a person does not want to do something, an escape route, some other document, my lord, let him specify. He ought to have specified. He does not do that. Inability to produce, they say, the documents. This is complete non-application of mine. They have not dealt with the judgment which I have cited of the Honorable Supreme Court and the High Court that mutation is not a proof of title. If it is not a proof of title, he could not have asked for those documents.
Okay.
Third, my lord, it is a wrong recording of fact which is there on record according to their own documents, my lord. Your lordship will now kindly take paragraph 51 of my writ petition. My lord, why this writ petition was filed? My lord, and your lordship knows, my lord, parties by consent cannot give jurisdiction if the court does not have, my lord. 51. It is submitted that the petitioner was not aware that appeals being numbered such and such stood dismissed for default on 21st July 2003 and 3rd July 2006. Hence, the petitioner could not bring it to the notice of this honorable court in writ petition number such and such, and in such and such, or in any of the representation, and also before the land acquisition collector. But because what happens is, if the appeal is alive, and if there is an order of stay, then the land acquisition collector has jurisdiction, my lord, because then I cannot do anywhere else. Well, both the parties were under a mistaken question of fact, my lord. And it is their appeal. These things I did not point out. He could have pointed out their appeal. Now, since it is open, now let them produce. Let them produce. They are not now. Now, in their opposition, what they say. Now, in their opposition, what they say, my lord. In their opposition, what they say with regard to my submission. Lord, you will kindly see this. How they deal with paragraph 51. Nothing, my lord. Appeals court order.
Not same matter.
Other matter in respect of the same. Where is it on record?
Order already gone back to me.
So all submission from the bar, nothing on record, my lord. Appeal court, while granting an order of stay, said, my lord, which happens that you want to settle the matter, parties can settle. You want to derequisition, you can derequisition.
Yes.
My lord, that appeal stood dismissed. And I have made this averment. And what they say, your lordship will finally see paragraph 10 and 11, which I have said in my writ petition, and how they deal with this in their affidavit.
This executor was no longer in force to the till date.
On what basis?
2002. Thereafter appeal was papered. Appeal got passed an order. Appeal got passed an order. This is my submission.
Or from the bar, my, yes. This is
Yes.
submission from the bar,
Yes.
no documents, my lord. Nothing annexed
On
in
the
the
basis
opposition.
of the appeal court order, we DDQ, sir.
Now, if your lordship kindly sees, paragraph 5, paragraph 5 at page 8. I have made a specific averment, my lord. Paragraph 5. With reference to the statements made in paragraphs 1 to 30 of the said petition, I deny and dispute each and every allegation contained made therein and say that those are matters of record. My lord, page 8, paragraph 5 of their opposition, my lord. This is how they deal with my averment. Yes, that these appeals have been dismissed. My lord, let them show that these appeals have not been dismissed, or what I am saying is wrong. Nothing. All submissions coming from the bar record says something. Do not admit. Let them show that this appeal is pending. At this stage, well, these submissions cannot be contrary to the
Yes, my lord, disputed. He has to show.
opposition.
He has to show. It's
If he admits, what more do I
have
show, man?
stated my petition. If he denied, he has to show the original document.
It is his appeal, my lord. Let him show. Secondly, now your lordship kindly sees.
I have stated it by oath.
Your lordship will kindly see. Yes, on oath what the party has.
And an oath in a repetition, it takes question.
On, of course, that is the law. That is what the Supreme Court has. Now, if your lordship will kindly see what he says, I have categorically stated in paragraph 10 and 11, he says yes, the matter of record. He does not say no, this is a false statement. Look, these are pending. He also knows it is dismissed. Otherwise, he would have shown that no, this is not dismissed, this is pending, my lord. For the first time in argument, they are arguing contrary to the pleadings, my lord. Second, my lord, now if your lordship kindly sees this order, which my learned friend has relied on the division bench, merely opined, which also happens that if they want, they can release. It is not a direction. My lord, it is. My lord, once my learned friend submits, then I'll make my submission. In between, if he interrupts, my lord, I did not interrupt him while he was. Sir,
I think this see the Honorable Chief Justice, Honorable Osipur Justice was pleased to dispose of the said CA. Suppose I'm saying directly to on the basis
Yes,
of
the
that,
appeal has been dismissed for default. The order was passed requesting the parties to, if they want, they can de-requisition.
passed into the order, we are
That order has not been annexed to your opposition. You have not annexed the order, neither you have annexed the notification of the Land Reforms Department de-requisitioning the particular 37062 square feet. That notification is also not annexed.
Disputing that, he has to produce that order.
Who is disputing? He says that it has been dismissed for default.
and
Why? That is their submission.
in opposition,
Dispose
he
of
had
the application.
This is not the submissions. It has been averred in the writ petition that those appeals were dismissed for default.
Same appeal. That is the main.
Come to page 3 of your opposition.
Yes.
You say 19 APOT 90 of 2002.
They
They also say that it is APOT 90.
43, page 13, paragraph 10,
And 130 of 2002.
POT
This-
number 53 of 2002.
After that, there is another number, which number is also recorded in the affidavit of opposition. In your opposition. There are two appeals.
This for default, that order, this is for default, that other portion, when we have already complied with that portion of the order. That is 2003 order. After 3 years.
Yes. That's all. Yes.
That will kindly take page 3, my lord. Subject to the condition, if the government want, they can de-requisition certain portion of the requisition property without prejudice to the rights of the party. It is a minor, it is not a direction. It is if they want, it is at your wish. Court is not saying that. Because the order. It is an
I've
observation.
understood.
It is not a direction, my lord, because the order has been stayed. So court has left it upon them. It is not a direction. First. Secondly, my lord, certain portion. My lord, my lord, this is with regard to certain portion. Admittedly, they are holding back 4,000 and odd square feet, my lord. The fight is over that, my lord. I am not saying that they have not given me back that possession, that portion, my lord. Now, my lord, since the appeal has been dismissed, so the interim order on which they rely, it does not remain in force. Of course, my lord, it cannot remain in force, my lord. Interim order, they want relying on an interim order when the appeal is dismissed. So if the appeal is dismissed, the order of Justice Kalyan Jyoti Sengupta stands. No appeal has been preferred, no recalling has been filed, my lord. So that chapter is over, my lord. They cannot revisit. And what my learned friend is arguing is not what is made out from the opposition. Nothing annexed. In fact, what I have stated is admitted, not even disputed by them. My arguments also cannot have it. Secondly, my lord, this order, well, I have stated in paragraph 51 of my writ petition that parties did not, at least the petitioner did not know. Till date, in spite of making these submissions in my writ petition, if I made a false averment, they could have come up, they could have annexed that, look, this appeals are pending. They also notice dismissed, my lord. They have admitted that. But argument is something, pleading is something else, my lord. None of my judgments have been, my lord, distinguished. The Honorable Supreme Court has held that if the occupation is illegal, I am entitled to compensation. And these were all writ proceedings, my lord, in which these orders have been passed by single bench, division bench, Supreme Court. So maintainability of my writ petition, my lord, illegal occupation because it affects my constitutional right, my lord. I am entitled to compensation by way of writ proceedings.
Okay.
These are my
Page 190.
Again,
I'm not making it. I just remind you, brother, what about the Poland justice? What about Justice Sengupta's order, brother? That is 2011. After perusing all the documents and papers, this court was pleased to direct and understand client. What today they to come for this court?
see,
Yes, to prepare a correspondence application or like that, nothing. State will file a petition, then you can file a supervision handover. It's an order, 2011 order. Assuming, application, about an order is taken.
That is what I have clarified in paragraph 51 of my writ petition.
awesome. That's
One.
Grateful
Thank
for the
you.
patient hearing.
Questions, yeah.
Heard Mr. Avinash Kankani, learned advocate for the petition, who concludes his argument. Mr. Pantu Devroy, learned advocate representing the state, also concludes his argument. Hearing is concluded. Judgment is reserved and made CAB. Where are you yesterday? Other writ petitioner?
I'm this petitioner, not in item number 2.
Three, you are the petitioner. এটা কাগজটা দিন।
The last 2 occasions, Lord, I already placed, Lord, the contention of my writ petition and, Lord, the exception, Lord, the last report which was placed, Lord, by the municipality and my exception, Lord, which has already been noted before your Lordship. Lord, a short recapitulation, Lord, not the entirety, but thereafter, Lord, I shall proceed where I left, Lord, on the last occasion. Lord, your Lordship once takes up, Lord, my exception.
Yes.
But, page 10 of my exception.
Here.
My Lord will find that by virtue of this order, the coordinate bench, but on 13th of October 2023, negated the first report which was handed over by the municipality with a direction. Only I shall read, my Lord, the page 10, last 2 lines. It starts with the surveyor shall also consider. Has your Lordship got it, my Lord? The surveyor shall also consider whether there are proper side space kept beside the building that is being constructed, which is the allegation of the petitioner who claims to be the neighbor. So, my Lord, the direction was that a fresh inspection has to be carried out to point out and report before this honorable court whether the side spaces at the fourth side of the offending construction which has been made, whether that keeps the adequate open space or not. That, Lord, I have already canvassed before your Lordship by placing the rules, what should be the requirement of law and what they have left out, even as per the report which has been submitted by the municipal authority. So I am not placing, Lord, regarding that portion. Your Lordship has also extensively taken note, Lord, what should be the side open space according to the law needs to be open and what is there. Even the municipal authority, though, my Lord, sufficiently tried to protect the private respondent, but as per the requirement of law, particularly the rules, my Lord, which I have placed, my Lord, the paragraph
E onwards.
Yes, E onwards, Lord, I have taken, Lord, note of, Lord, in my exception, what is the present position. Now, my Lord, thereafter, from my exception, Lord, I was stopped at the point, Lord, when, Lord, I was placing page 14 of my Lord's, Lord, my exception, sorry, Lord, page 14 of my exception. Where, Lord, I should also point out that I was placing that what is a requirement, it is a, Lord, construction which is nearer to a railway track. Lord, there is a RTI information that has been obtained from the railway authority, which I have annexed from page 14 onwards, wherefrom it will reveal.
Yes.
Wherefrom it will reveal that, my Lord, the railway circular issued by the Government of India, Ministry of Railways, that suggests that if it is nearer to railway track, then particularly in the close proximity of the 30 meters, then first, no objection from the railway authority is absolutely mandatory. And if such no objection is not taken, then the municipal authority ought not to have granted any sanction. Because, Lord, may I just remind your Lordship, my case is not only based on Section 218 of the West Bengal Municipal Act, wherein the municipal authority is given power to demolish an unauthorized construction which is made either without any sanction plan or not in apropos to the sanction plan. But my case is also based on Section 217, because I have already placed my representation, wherein I say that this
sanction plan which has been obtained, that is being done by perpetration of material misrepresentation and fraud before the municipal authority. And if that be so, the 217 gives power to the municipality to cancel the entirety of the plan.
17 has a ground of misrepresentation and suppression. That's 15.
Just like not section 397 of the Kolkata Municipal Corporation Act. I just hand over.
Yes, yes, yes.
So that your lordship can get smart answers. I'm not placing not the entirety. The lordship kindly use that. The provision itself, its power, 170.
Dinner.
So that when I was placing this portion on the last occasion, I must, being an officer of the court, remind your lordship, my learned senior friend, not representing the private respondent in my matter, he not submitted before your lordship that railway circular does not have any bearing effect with regard to the approval or grant of sanction by the municipal authority, because they municipal authority is self, as per my learned senior friend, it's a self-serving court, it's a separate statutory body. There are certain prescribed formalities that has been laid down in the law and the rules frame thereunder. So whatsoever the railway authority or the other local body or the Ministry of India guidelines are, the municipality is not about to adhere to all those. Now, my lord, may I just place thereafter, my lord, this your lordship takes up page 14. My lord, this is my, from my exception. This is a RTI query that has been made under section 6. I have annexed this. Kindly turns over to the page and page 15. It is the answer. The query is, what is the statutory provision as regards keeping of mandatory open space from railway track and on land under the municipal area in the state of West Bengal for construction of a multi-story building? Now, answer is, a copy of the instruction regarding procedure for issue of no objection certificate for construction stroke redevelopment of government and private building on land adjoining railway boundary issued vide railway boards letter dated such and such, which are self-explanatory, is enclosed. Now, I'm not kindly turns over the page 16. I will not read the entirety. Kindly takes up 6 line from the top of that circular, which is not mentioned. It starts with, it has been mentioned that, has your lordship got 6 line from the top? The sentence starts with, although it has been mentioned that
Yes.
an open space of approximately 30 meters between the railway land boundary and nearest edge of the building, such and such be suffice. It is also stipulated that sites and towns where the land is valuable, it is not expected that the landowner of the plot have a large vacant space between his building and the railway boundary, and it is deemed that railway interest will be adequately safeguarded if the sufficient vacant space is left, so that the ensured development of the future road access and drainage outside the railway land, and to avoid request to surrender the railway land for such facility in future date. The duties and role of railway officers regarding the dealing with utilization of the land as adjoining railway land boundary have been clearly defined in such and such. Now 2.0 million. Railway NOC, no objection certificate, is required for construction of building within 30 meters from the railway boundary as per para such and such of IRWM. So, first, they will have to apply the 30 meters is the bounded area, prohibited area rather, from the railway track. And if it is falling within 30 meters, then they will have to apply for no objection. The railway authority will give no objection. Look, this is a provision, but it has been mentioned. If you turns over the page, 3.0, not at page 70. After receipt of request, this is the request on behalf of the person who intend to raise construction. After receipt of request, the site verification is to be done by the field units. Field officers should check and clarify the width of the railway land and the distance of plot from the railway boundary. Rail level, ground level, etc. shall be taken. Sufficient open space be left between the railway boundary and nearest edge of the building to ensure that it will not result into actual of various easements rights as mentioned in 1.4 above. Plot should be marked in the sketch with the reference of the KM post and the permanent structure railway land which shall also be verified with the certified land plan. Now 4.2. A drawing showing all aspect as mentioned in para 3.0 above and the other aspect like drainage arrangements, access arrangements to building, height, length, width of the building, distance between railway boundary and nearest edge of the building be prepared, which will jointly signed by all concerned. Next, on receipt of verification from the field units, further scrutiny to the request is to be done in the division. The proposal may also got verified if required from the construction unit to confirm that the land is not under acquisition. Next 6.2. The proposal of NOC duly approved by DRM should be sent to the headquarters. The plan should be signed by CEG or SAG officers dealing with the subject in the headquarters in token of his approval. After approval of CEG or SAG officer, one copy of the plan should be kept open in the headquarters for record. Now, 7.2, I am not disturbing your lordship for the timing. Kindly turns over the page. Provisions I shall place.
Is
Your
there
lordship,
any provision in the municipal act?
I'm coming. I'm coming. Just I shall place this, and thereafter, I shall answer to your lordship's query. I'm grateful, I should. It is the 9.0 says, it's very important. As regards compliance of provision of development control regulations and other rules issued by the state government stroke local authorities, in this regard, it is for the state government stroke local authority. The local authority definition, the municipality is also a local authority. To examine and ensure compliance of the same. The provision of IRWM are not meant unnecessarily restrict the utilization of the long adjoining railway land on the plea that such land may be required for future development of the railway system. In case land is required by railway at a future date, it is only fair that the same is acquired after paying the due compensation for the land and the build-up property thereof. So, my lord, the railway authority are also conscious. They are not saying that it is unnecessary at 30 meters. It is not mandatory that always to be kept open. I am arguing something which is against me. But you have to notify the railway authority first. They will examine. And if they feel, no, this is something where the railway track needs to be wider, and they are planning that in future they may acquire. So the no objection from the railway authority, it is something which they will have to apply. The railway will consider. There are other provision also where it has been written that how the building will be constructed, what should be the piling system, whether it will affect the railway track line or not. Everything will be under their guidance so that they can ensure the safety and security of the railway in one side, as well as in future, if it is required for the railway, the land is to be acquired. So they will also have a say with regard to the permanent construction which is being made 30 meters adjoining to the railway track.
Is it a general provision, or if it is come within the 30 meters, then only
Then that is the circular
otherwise, if
itself
it is
says
beyond
Otherwise,
30 meters, it is not
it is
required.
not. So, that is the circular which I have annexed in my exception to the report. Apart from whatever the statutory dereliation that is there in the construction, this is also something which my client has got from the RTI information, and that's why I have relied on this. Now, to your lordship's query, as well as the submission that was made by learned senior friend on behalf of the private respondent, that being a railway authority who do not have anything to say with regard to the sanction plan, they cannot jump up and say they have certain things to be raised. And the municipal authority, rather not duty bound or statutory obligation, does not have anything with regard to the municipal authority to adhere to whatsoever the railway guideline are. To that effect, my lord, I submitted before your lordship on the last day that it is, my lord, there are various authorities of the government, like, my lord, environment authorities are there, fire department are there.
Yes.
They issued, my lord, guidelines from time to time. Your lordship knows, for the purpose of now construction of a multi-story building in the corporation area or, my lord, the municipal area, if it is a high-rise building, there are certain guidelines of fire department that if it is beyond this height, you have to keep the separate gates or arrangement for the fire extinguisher has to be there, or there are separate access so that the people can get evacuated in case of any fire emergency. So these are the guidelines that are there. But the municipal authority at the time of granting of sanction has to adhere to those guidelines. Like environmental guidelines are there at the time of making construction. So the municipal authorities, they are the authority who are going to sanction the building plan, but they will have to keep strict vigil with regard to the guidelines that has been issued by the other authorities also. But I could lay my hand, in respect to this proposition. In one of the judgment, reported in 2021,
Yes.
volume 10, Supreme Court cases, page 1.
Yes.
But I just hand over this. It's the longest judgment
Okay.
containing more than 100 pages. Like it's a celebrated judgment, Supertech Limited. But may I place paragraph 160? From the commencement to completion, the process of construction by developers is regulated within the framework of law. The regulatory framework encompasses all stages of construction, including allocation of land, sanctioning of the plan for construction, regulation of the structural integrity of the structures under construction. Now, kindly marks obtaining clearances from different departments within bracket fire, garden, sewage, etc. And the issuance of occupation and completion certificate, while the availability of housing stock, especially in metropolitan sites, is necessary to accommodate the constant influx of people. It has to be balanced with two crucial considerations: the protection of the environment and the well-being and safety of those who occupy these constructions. The regulations of the entire process is indeed to ensure that the construction which will have a severe negative environmental impact are not sanctioned. Hence, when the regulations are allegedly violated by the developers, more often than not with the convenience of regulatory authorities, strikes at the very core of urban planning, thereby directly resulting in an increased harm in the environment and the dilution of the safety standard. Hence, the illegal construction has to be dealt with strictly to ensure compliance with the rules of law. My learned senior friend cannot say that there are the other guidelines issued by the other authority, which the municipal authority does not have to adhere. But it is very specific language. The Honorable Supreme Court has made it very clear that the other guidelines issued by the various local authorities has to be adhered. Paragraph 164. Here the quotation of one judgment is being made.
Yes.
Paragraph 24 is being quoted. Structural and has your lordship got it? Structural and the lot area regulations authorize the municipal authorities to regulate and restrict the height, number of stories, and the other structures, the percentage of the plot that may be occupied, the size of floods, schools, and the open spaces, the density of populations and the locations, and the use of building and structure. All these have, in our view, and to achieve a larger purpose of the public health, safety, and general welfare. So our front setback provisions, average alignments, and structural alterations. Any violation of zoning and regulation laws takes the toll in terms of public welfare and convenience, being sacrificed apart from the risk, inconvenience, and hardship which is posed the occupation of the building. So, my lord, in so many language, explicitly the Honorable Supreme Court has made it clear that it is not the municipal law which needs to be adhered, but while granting sanction, the other guidelines of the local authorities needs to also adhere, and these municipal authority rather duty bound to perceive vigil that those guidelines are to be fulfilled and adhered to while making such construction. So, my lord, the information which I be from the bar has informed before your lordship, not from materials, that in the meantime the railway authorities have also issued a notice saying that the building is illegal. But I may bow down before your lordship so far as the legal proposition is concerned. The action with regard to 217 and 218 can only be taken by the municipal authority. But the railway authority can agitate that you have not adhered to my guidelines. That much authority the railway have, because they have issued a guideline being a local authority, and the municipality on the side being another local authority is duty bound to perceive vigil that has been complied with or not. So when another wings of the government is saying that no, this no objection is mandatory and you have not fulfilled, so the building is illegal, the municipality cannot say I will shut my eyes and I will not give any credence to such allegation of the other local authority.
The railways have filed in a report.
But the,
How the document is coming.
because in my petition, though I have pleaded blood at these violations, also my exception, but railway authorities are not part. But I must be candid. The second writ petition which has been listed before your lordship, there will not be railway authorities. The railway can throw light on it. I am only canvassing before your.
Yes.
I am just canvassing before your lordship. What is the provision of law? Okay. That's why I said.
22.
There's no allegation in print.
The motion was the first petition.
No.
The review of
First,
not a part.
Hold.
I'll read that. What was the
Adhering to the.
read the river?
Yes. Next.
Lord, may I come back, Lord, to Lord, my exception, Lord, I have accepted.
This you have concluded.
Yes.
It is.
Lord, I shall, Lord, make up a copy and hand over before your lordship the judgment.
Second petition, the review authorities are part. Not in the person. You should not say anything about it.
Lord, I
You shouldn't
say,
be saying anything about it.
Lord, I am placing the provision of law.
What is it?
What provision of law I shall place, Lord, my learned senior friend should not dictate.
No, not dictate. I'm not dictating.
Lord, now, Lord, may I,
Party is absent. And he says that he's going to read that part.
but the law is there.
Refer.
Yes.
Now, Lord, what is, Lord, the opposition that my learned senior friends, Lord, the client, being the private respondent number 710 is being placed on record. May I just suggest that? This portion I have not placed, but page 3 of their opposition. They have taken a point of suppression by me.
Yes.
Paragraph 6, Roman 2. Has your lordship got it? They have taken a point of suppression. What is that? Lord, the paragraph suggests that there is no mentioning of the said in the said writ petition, that is my client's writ petition, that a civil suit is pending before the court of the learned second civil judge junior division at Sridharpur, district Hooghly, being title suit number 667 of 2022, and that the same property and respondents are involved, and that only petition is different here. That petitioner, or it should have been petitioner, that the plaintiffs in civil suit and the petitioner hearing are the same locality and neighbors, and by filing writ petition is only to harass the respondent. The petitioner is trying to mislead the honorable court by not mentioning the pendency of the civil suit, and that an order of injunction has already been passed by the learned court below, and the next date of hearing is 16th of July 2024 before the learned court. So, look, the point of suppression is being made that I have not disclosed the title suit number 667 of 2022, where a subsisting injunction order is there. This has been affirmed, my lord, on 12th of June 2024. My lord, kindly mark this because I shall take that point also, which I have dealt in my reply. No, my lord, senior friend is candidly saying he will not place this point.
Now, that's a different matter.
Page 9 of my reply, I have annexed the plain, wherein it will reveal before your lordship that the private respondent, being the plaintiff, has initiated a suit saying that allow me to continue with the construction work. Again, some of the neighbors of that locality wherein I am not a party. So, my lord, a proceeding initiated on the behest of the private respondent in respect to some other person, but there cannot be any provision that they are saying that I am guilty of suppression, wherein I was not even a party. And secondly, on the day, this has been affirmed by the private respondent. On the day of affirmation, he is saying a subsisting order of injunction is there. I have annexed in my opposition, in my reply, that much prior to that, the interim order was vacated. Even in that, initiated by him. On the day, I must be I am conscious that I am making this statement before this honorable court, that on the day of affirmation, even much prior to that, the interim order was not subsisting, but a conscious wrong statement is being made. But I have annexed your lordship, page 25 of my reply. But page 25, my lord, get 31st of January 2024 order. My lord, get let the interim order of injunction is vacated. The handwritten copy. Not quite legible. So, my lord, it was vacated on January 2024. It was not subsisting, Lord, when the affirmation was being made in June 2024.
Vacated on?
It was vacated on, Lord, 31st of January 2024.
Yes. Yes.
Page 7 of their opposition. I shall place before, you can say before your lordship, page 7. That's why consciously, in support of that paragraph, they have annexed an information slip, page 7. The information slip suggests they have asked two questions. উপরিউক্ত মোকদ্দমা কিসের জন্য ধার্য আছে এবং মোকদ্দমার পরবর্তী ডেট কি আছে, not that whether there is a subsisting order of injunction is there or not, but in support of this statement, my lord, this annexure is being relied upon. Now, the last point of mine, my lord, in respect to the opposition that they have filed, kindly turns over the page 8. The municipal report as submitted before your lordship that suggests that the construction is as per the sanction plan adhering to law, and that some deviation are there, though they have tried to protect the private respondent but could not do so in a proper manner, which I have placed. Now kindly see page 8, they have annexed with their opposition. What is page 8? Page 8 is depositing an amount of rupees 10,000. Kindly see the date. This has been done in 17th of November 2023, when the writ petition was pending. Direction was passed from time to time. Here, on account of, kindly see, what is lordship directed, the coordinate bank directed the fresh inspection to be done on 13th of October. So kindly mark the date, 13th of October 2023. This honorable court negated the first report and directed a fresh inspection to be done, and that report has been placed before your lordship's court. So that direction was 13th of October. What is this slip, miscellaneous receipt slip relied by the private respondent? This has been done after the order passed by your lordship's coordinate bench in 13th of October. This is 17th of November 2023. The municipality is accepting money on account of development fees for additional construction. So I may say that at least from this document disclosed by the private respondent itself, it is proved that apart from sanctioned building plan, there are additional construction that has been made. And your lordship has a vast experience, it's a general procedure, though not ratified by the law, that in Howrah, your lordship knows that as-built plan, retention fees now permissible to such an extent, though the Kolkata Municipal Corporation Act frames a guideline as per the rules, regular retention fees. But the West Bengal municipal law till date doesn't suggest anything to that scope. But the municipality is accepting money on account of some additional construction that being made by the private respondent. That too during pendency of this instant writ petition, wherein from time to time orders are being passed from this coordinate bench of your lordship's court, that inspection to be done, what is the actual picture bring out for the court. So it's a deep-rooted nexus, it is proved by way of documentary evidence itself.
Yes.
That the municipal authority is taking side of the private respondent. But your lordship kindly once looks at page section 218 now. This has been a certain amendment. 218. Now, after that, there is a notification. I know there is an amendment made. The amendment suggests that though the original provision, my lord, kindly see, does not gives any power for retention, but subsequently, recently, a notification is being issued wherein the municipal authority has given power to regularize certain minor, I must quote the word minor deviations apart from building plan, what is sanctioned building plan, upon taking fees. But for that reason also, the Board of Councillor has to take a decision to that effect. But when a substantive writ petition is pending before your Lordship's court, and the municipality is taking a conscious stand that no, what is construction is there, that is apropos to the plan and the rules or regulations that has been framed. But on the other hand, apart from this receipt, there is no, my lord, order from the Board of Councillor. It's a joint body. It's not about one single chairman or something, one person can decide this. The power is, my lord, given to the Board of Councillor. That's why 218, the language starts with, if the Board of Councillor is satisfied. It's not chairman or any private individual or any private officer.
You have the copy of that notification?
Kindly see the amendment, the insertion of the proviso of sub-rule 2. This has been incorporated. Yeah, just place before your Lordship. Provided further, this is not inserted thereafter. This is being done
Yes, sir.
notification dated 27 July 2023. But under that, may, by order, so who can do so? Board of Council. By order, regularize the minor unauthorized erection or execution of any minor work without sanction under these rules, or minor deviation from the sanction plan or execution of any minor erection of or work in contravention of any sanction plan under this rule, keeping regard to the following things as the case may be, on payment of fees stroke charges by the person responsible for such portion of minor unauthorized erection at the rate as may be determined by the state government by notification. Now, there are certain guidelines which has been mentioned. While doing so, this regularization of minor unauthorized erection, they will have to adhere to all these factors. That is not from A to N. And lastly, provided also that the Board of Councillor, if they deem fit, may refer such cases of minor unauthorized erection or execution of minor work without sanction under these rules, or minor deviation from the sanction plan, or execution of any minor erection of work in contravention of the sanction plan under this rule, for the purpose of technical consultancy to the state level building committee constituted by the state government for reviewing the issue of regularization of such cases. This, in my respective submission, even does not any of to benefit of the private respondents, because the payment of fees has to be prior to a decision of the Board of Councillors. So, your Lordship, kindly see the stand of the municipality. Before this honorable court, they are saying no, everything is all right. On the other hand, when the writ petition is pending, they are accepting fees from the private respondents for the regularization, attracting this provision, wherein this provision suggests this has to be by virtue of an order passed by the Board of Councillors.
Yes.
And I have already canvassed what is the requirement of law and what is being done over there. If this be said to be minor, then nothing is major. And apropos for everything, the railway authorities regulation as well as the manner and the nature by virtue of which this sanction is being granted, it attracts the provision of 217 also. So the municipal authority is duty bound to look into all these things and to exercise its power under 217, apropos 218, so that already the illegal construction that is being made, not adhering to the rule 50 of the West Bengal building rules, that needs to be demolished, and thereafter to scrutinize whether this plan, whether at all being sanctioned by not misrepresenting or making fraud before the municipal authority.
But then the plan that was sanctioned, you come to a conclusion that there was misrepresentation or any suppression of material facts, you say that there is deviation of plan.
But
So
are
there
two
is a plan.
different- There is a plan.
There
I
is a
said
plan.
that plan,
If that plan is sanctioned in accordance with law and one deviates that,
that is not 280
separate.
part.
Yes.
That is 280 part.
But how the court can come to this conclusion that there was a misrepresentation or
So great,
suppression?
But the when Milord, I am applying before the municipal authority, applying, Milord, your lordship knows that my LBS, that apart from soil testing, they will have to make a structural stability plan what is there. Giving Milord the entirety of the locality, what is the four corners of my building. The adjoining one corner is the railway track. If had it been a case that this has been disclosed in the LBS plan that has been placed for sanction, then the municipal authority ought to have inquired into the matter. Kindly see, Lord, I have data plan. Last occasion, Lord, I was handed over Lord, one plan.
ওটা কি ছিল ওখানে?
Plan was submitted before at the time of filing the report. That was that.
First report or second one? Second. এটাকে বন্ধ করা আছে। হ্যাঁ, একটা প্ল্যান আছে। এটা একটু খুলুন তো। প্ল্যানটা আছে। এটা ব্যাক একটু করুন প্ল্যান। রিপোর্টটা আছে না? থেকে আমার ঢুকিয়ে রেখে দেবে ঠিক আছে।
Your lordship get Milord, clearly the right side, Milord, the just Milord, before Milord, the left hand side of the area statement.
Yes.
You get Milord, the entire Milord boundary is being given. So Milord, it is the railway track is just adjoining is one of the boundary of the this Milord, offending construction, but nothing is being disclosed over here. I say, Milord, the authority, they will have to come to a clean hand saying that these are the Milord, boundaries of my building. I want to propose this. This proposal needs to be ratified by the Milord municipal authority. But if this does not disclose the real picture, depicts the real picture, Milord, this is the material misrepresentation that has been done. by virtue of which this plan is being obtained, and this gives power to the municipal authority to annul the entire plan, applying provision under 270, which I placed. These are my submissions. I'm grateful. If my junior will be there, if necessary, I shall come back and give reply. After that, I'll answer. Sir.
903. Two 9103, you adopt the submissions advanced on behalf. 29103, you adopt the submissions of Mr. Mukherjee.
Addition by law.
Mr. Sannal, there is no opposition.
No,
There was no order also passed. You intend to file in opposition or rely on the opposition that is filed in the other writ petition?
Because I've been going on preliminaries, basically. I've been showing you those ships that the allegations that have been made are quite frivolous and because actually address issues on points of law, basically, where this position has not been. Of course, I would like to bring a short affidavit in opposition because of the fact that there has been material suppression of fact, and in fact, he is not entitled to really maintain this position. That I would, because of the pictures that his house, which he's talking about, has left no boundaries. It's right onto the boundary, my boundary. And now he seeks equity and says that my building should be demolished and I should be keeping side space. Whereas he ignores that aspect of municipal. That I would like to bring on record by short affidavit. No more than
In 29103, in 10868, you have
one of
No, no.
the first.
the first one. You want to file a supplementary.
Just one additional paper. Because I would like to bring on record that
With
there is
regard
no
to
side space left by him.
29103, there is no such opposition or there was no prayer to file any.
Then I'll file an opposition. Because I just make it clear one or two things.
Okay.
Anyway, they're depending on a railway manual which has got no statutory force. That's what I'm saying.
It is a instruction from the railway officer.
You are a party in this.
Yes,
Yes.
part of your party. They made a spot inquiry to measurement. It is not only within 30 meters, but very close to the rail.
So what you do is you you file a report. Since you are a party in this, you file a report. He will file a opposition. In this.
Yeah, assigned. This is assigned.
That's fine.
They submitted application and this has been assigned. The assignment is আছে না এটা?
Assigned.
এটা আছে।
But I'll just use a very short affidavit.
আচ্ছা।
The building abutting to the railway line.
That's okay. That's fine. I'll be
Close. Very
I'll
close.
be must be petitioner because it's got no statutory force. That manual has got no statutory force.
Since in first one again, if you file a supplementary, then they will file a reply.
Yes.
He has concluded his argument. This was never indicated the since the argument was initiated.
And they have already filed their opposition. And another supplementary and a opposition.
But again, Mr. Sanal, this will delay the matter.
So then I can hand over something.
And
I'm just saying, because a person cannot take advantage of his own wrong.
আসুন আসুন আর মিস্টার তন্ময় মুখার্জি লোনের এটা করুন হেডিং করে দেবেন WPA 10868 of 2023 আর মিস্টার তন্ময় মুখার্জি learned advocate for the petitioner who concludes his argument. At heading WPA 29103 of 2023, Mr. Sudeep Sannal, learned advocate representing the private respondents, who seeks to file affidavit in opposition. Let's search affidavit. Mr. Sannal, when can you file it?
I'll do it today.
Yes. So let's search affidavit in opposition will file by Monday, that is 11th. Stop. Reply there to if you file 11th Monday hole by Wednesday. কবে আছে? You can file it by 2 days. On 11th, by 11th they will file.
Well, within 7 days, because
Reply there to
instruction is required.
reply there to
Another point
if
also.
any within a period of 7 days, within a week thereafter. তাহলে ওই উইকটা গেল, তাহলে আমাদের কবে গিয়ে আমরা যাচ্ছি, এটা কবে আসবে তাহলে?
All are reciting the same. One is 11, one is 12, and one is 13.
That is what is required, recorded in the order.
Supporting the violation.
That is recorded in the order.
And only making submission, not drawing.
Sit down. কি বললাম? 18 তাহলে আমরা তাহলে মান্থলি হলে মান্থলি তো উইক হলো, তাহলে 18 থেকে হলো 19 হবে না? 20th. On 20th.
Railway authority shall file a report.
Report, yes.
Our report, some more time will be required because there are some procedure regarding.
Since I have started hearing this, so I think make it within this period, because it is going 20th. Today we are in 7th, so almost two weeks you are getting time. Huh? Railway, your respond number?
This was
6 and 7.
Respond number 6 and 7. A railway authority is also directed to file a report by the returnable date. Release this matter on 20th November. Mr. Sannal, give an advance copy of your to them so that they can make it. Advance copy of the affidavit of opposition we served upon the oita the 29103. Oh yes.
This can be a good one.
Before the second matter, railways আছে।
All are reciting the same place. One is 11, one is 12.
একটা নোট ওখানে করে দিন তো তন্ময় মন যেটা কনক্লুড করেছে নোটিফিকেশন dated 27 July 2023 is taken on record. Mr. Sannal, I am keeping this notification in the record. Yeah. You take this.
Actually, this is by G+4 building. There is no montage. Only 7 feet.
File, let them file the opposition.
Problem is, that was sanctioned 18. They have been making complaints.
Okay. Either. Next. Petitioner.
Our report will not.
Yes.
Exception to the report has also been filed.
What is this scan 1 of 22? And one টা কি আছে? Number 10.
So the one of the respondent, private respondent,
Huh. 10.
number 10, transparency circle.
And this copy has been given. Can one?
That one we have not been.
You have not served copy?
Can't go check. Can't
I have served the 40 minute to
You have not served upon the other side. For the respondents, the learned advocates were appearing for the respondents. Give a copy. This is an application for substitution of defendant and respondent 10.
Respondent number 10.
Give a copy of this application. Who are the legal heirs? In which paragraph have you stated?
Legal heirs, sir. Paragraph 3. Page 7.
Mother.
One is the wife of respondent number 10, and one is the daughters, Lakshmi Santa, and one is this one of the wife. Sita Singh Gupta, and one is Sobita Singh.
Right.
Order 14th of May.
Can I order goes into for next week?
14th
This
of May.
Huh.
That is for the private respondents, so that 8, 9, and 10.
Huh.
Find 8, 9, and 10. Uttio Roy and one Arnob Mundal appeared. 8, 9, and 10 were at private in original report. But 10 died. I substituted the years of 10 in this application. But I served them directly. One has been received, but other two, but I think one has been, oh sorry.
Come back tomorrow. Find out who have been served. You have give a copy to
I
not this week.
handed over one
Well, only one submission, but I have received just now, but not three substitution petition without annexing the death certificate.
Death certificate not there.
They said the defendant number died, my lord. How-
Right, my lord, that is not there. Because one of the-
So how did that-
He should withdraw by the
What out? But in that way, well, very time not on this. Sort of you are
he should withdraw this application. I will place
let me. But this from 8 to 10, your lordship will, I know I have, going to tell it, private respondent in the writ petition. But on their behalf, 8 to 10, Uttiyo Roy, Honorable left here. Well, lordship, find in the order sheet of 14th of date, well, be allowed. So I can contact this Uttiyo Roy and well, so and so, who was appeared on behalf of the also 10. And well, assist certificate of
The person who has died is your mother.
no. 10 is, well, 10 is,
The mother of the petitioner.
no, the respondent, private respondent. Well, automatically come to the 10, but
You
if
come
the-
to paragraph number 2 of your application. The petitioner is Jogeshwari Singh Babu, is the daughter of the respondent number 10. Annex the death certificate.
paragraph 2 of
Paragraph 2 of your application.
my the mother of the petitioner died. But this is my deed petition. The mother of the petitioner means my the mother of the deed petitioner.
Mother of the
Deed petitioner. But the
whom you intend to.
the right derived from mother.
So who are the legal heirs?
But the legal heirs, I intend to substitute in the, but the rest or well, the heirs of the respondent number 10. They are he is the private respondent. He is the private respondent. In paragraph,
Where is the legal heirs?
stated in paragraph
11, 10.
paragraph 10 of the respondent number 10. The respondent number 10 died.
If the respondent number 10 died, my lord, the learned advocate who is
Produce the death certificate and then I will hear the certificate.
Without
annexing the
basically appreciate one thing.
Hmm?
Let me allow, let me
Learned
allow.
advocate for the petitioner is directed to produce the photocopy of the death certificate. For the petitioner is directed to produce the photocopy of the death certificate of deceased respondent number 10. Is this matter? 22nd.
But in the meantime, the service of this
The
application.
copy of the application be served upon
Appearing respondents.
appearing
Well,
respondents.
already I have handed over a copy.
Give a copy to the state.
Here and now I have already.
If you have given who has been left out, he will be given. Huh? Yes, sir.
complete copy with the annexure.
Well, composite copy should be, sir.
Uh,
এটা বড় তোমাকে টেস্ট কপি দিতে হবে
Without certificate.
I don't know, he should withdraw this constitutional application by the affix annexing the
It is not making any sense.
I have not heard
Annexing that.
the substitution application
fine.
without death certificate.
করো that supplementary affidavit direction দিয়ে দাও।
Yeah.
ওই যেটা বলুন ডেথ সার্টিফিকেট প্রডিউস করবে ওখানে বলে দিন যে ডাইরেক্টেড টু ফাইল আ সাপ্লিমেন্টারি অ্যাফিডেভিট অ্যানেক্সিং দি ডেথ সার্টিফিকেট কপি অফ দি ডেথ সার্টিফিকেট
ফিশি ব্যাপার আছে it will
That may I have, my lord, brief, my lord, mention a matter, my lord. Here a commissioner was appointed to take evidence, my lord. The time to complete the commission has expired. My lord, if it could only appear as to be mentioned for the time to be extended for the learned commissioner to complete the evidence, my lord. My lord, may I hand up?
Year to the
My lord, the year is, it's an old suit, my lord, 2009, CS 331 of 2009, my lord.
notice in the who is for the
Yes, we
defendant?
served a notice and Miss Sonal Shah's appearing online, my lord. She's there online.
Okay.
She's there. My lord, an order, if she's here, my lord, if it commences to
mute হয়ে গেছে অনলাইনে আছেন I cannot hear you. I think your system is muted.
try, I'll wait in case she can.
It will appear under the heading to be mentioned. Okay.
My lord, may I mention, my lord, in respect of 2010 suit, my lord, lordship leave to file, my lord, fresh vokalatnama, my lord, with my lord, affidavit of competency. My lord, FCI, my lord, Food Corporation is my lord, the plaintiff. It was, my lord, dismissed for default, my lord, in view of change of panel, my lord, new set of advocates have, my lord, been engaged. Now, my lord, fresh vokalatnama is being filed, my lord, which will leave, my lord, because, my lord, suit is already dismissed for default.
Suit for which year?
Suit of 2010.
আচ্ছা তো
Your lordships, kind leave to mention one matter, your lordship. This is a PLA matter, your lordship. This is a PLA matter where the administrator application has been made by the mother, your lordship, who is suffering from a terminal disease. If your lordship kindly recalls, the lordship had extensively heard this matter because the parties were trying to come at a consensus. Where on the, in fact, the parties mostly has been in principle.
তো চয়ন গুপ্ত was
Yes, your lordship. Yes, your lordship.
what is the আমার তো determination আছে
Lordship till 14. Lordship has the determination. Lordship, maybe it can be if lordship.
no.
Lordship will kindly has
Sorry,
been
sorry.
hearing it.
No. চলো next.
Lordship on PLA matter for inclusion, your lordship. It's a new chamber matter, new chamber application.
দেখি না চেক আচ্ছা
That is my application, my lord. The trust preferred an application through Sevais, my lord, for seeking permission, my lord, to sell and dispose of a property, my lord, which is fully tenanted, my lord, and it has not been maintained, my lord, for the last 50 years, my lord. And the condition of the trust is very much, my lord, in distress condition, my lord. For that reason, my lord, trust resolved, my lord, to dispose of a property, my lord, situated at 6 Sheepday Lane, my lord. For that reason, my lord, we have already, trust has already entered into an agreement for sale with the proposed purchaser, my lord. And now, my lord, the trust is seeking permission from your lordship, my lord, to the trust has preferred this application through the Sevais, my lord, to grant leave, my lord, to sell and dispose of a property, my lord, which is fully tenanted, my lord, and not well maintained for the last 40 years and above, my lord. The condition of the building is very much dilapidated, my lord, and considering the situation, my lord, the trust has already entered into an agreement for sale with the proposed purchaser and received certain amount, my lord, and my lord, to give effect of that contention, my lord, the trustees has preferred this application before your lordship, my lord.
you have annexed the valuation
Valuation, my lord, more than 50 lakhs, my lord, but the consideration price is which has been fixed, my lord, by the Sevais as well as the
you
proposed
make
purchase.
a publication of
My
this
lord, kindly pass the direction, my lord. We are ready, my lord.
My lord, kindly give pass the direction, my lord, to effect the advertisement, my lord. We will obey the order of the honorable court, my lord.
And who is for the defendants? Is there any defendant?
No, my lord, no, my lord. So only the Sevais preferred the trust preferred the application, my lord, on behalf through the Sevais, my lord. In the agreement for sale, my lord, all the Sevais put their signatures, my lord. Later direction we passed, my lord, for advertisement, my lord.
Which paragraph you have stated?
My lord.
In which paragraph you have stated that this property is required to be sold out? কোথায়? Paragraph number.
My lord, page 10, paragraph 50, my lord, there is no income of the said property. He is purely being occupied by lessee tenant trespassers. There is huge amount of property that be lying outstanding, and the lessee who was liable to pay was not paying rates and taxes and other outgoings, my lord. I have already stated, my lord. Considering the situation, my lord, we have in the compelling circumstance decided to dispose of the property, my lord. Even, my lord, in paragraph 19, my lord, we have submitted the public auction on advertisement or any manner for sale may kindly be considered. Even we are ready, my lord. In paragraph 19, my lord. Because trust is not in a position, my lord, to maintain the building, my lord. The tenants are not paying their rent, my lord, for the last couple of years, my lord.
You are the trustees.
Yes, my lord.
You have been appointed.
Yes, my lord. My lord, it is a family trust, my lord. Automatically, after the demise of the original trustee, the legal heirs be appointed, my lord. And all the trustees have put their signatures in the agreement for sale, my lord, which I have also annexed in paragraph 96, my lord. Page 96, my lord. There are 4 trustees, my lord. 4 trustees have consented, my lord. The agreement for sale with the proposed purchase at page 96, my lord. Well, we are ready upon compliance of all formalities, my lord. We intend to dispose of the property, my lord.
To cause valuation of the property. Ashok. This is an application seeking permission for sale of the trust property at premises number 6, Sheepday Lane, Police Station, New Market, Kolkata 700087. Mr. So and so, learned advocate appearing for the applicant, submits that the property is getting dilapidated day to day and could not be maintained properly for which reason the trustees have filed this application for sale, application seeking permission for sale. He also informs that an agreement for sale has been entered with one Srimati Kiran Singh for a consideration price of rupees 17,50,000, which is the best available price in the market. So, he seeks for appropriate orders. It is found that no such valuation report of the property in question has been annexed. A registrar, accordingly, registrar original site, High Court Calcutta is directed to cause valuation of the property comprised within premises number 6, Sivte Lane, Police Station, New Market, Kolkata 700087 by an impaneled valuer and file a report, furnish report on the returnable date. List this matter on
My lord, may I?
on 2nd December. No, yes, 2nd December.
My lord, parallelly,
Second,
may I obtain?
What is it? 9.
My parallel, may I obtain a valuation from the registration
Not
office,
required.
my lord?
Not required.
Item number 2. My lord, I appear on behalf of the respondent in this application. My lord, yesterday I had submitted before your lordship, my lord,
Not today.
applicants of this application, my lord, they
None appears
perpetually
on
do
behalf
not.
of the petitioner. देखिए, application none appears on behalf of the petitioner. Accordingly, the application is dismissed for default.
I'm grateful, my lord.
Huh?
No, I am appearing for the chat box. Say he is a supporting defendant, my lord. He is
not the
appearing.
petitioner.
No, he is not the petitioner, my lord.
I am for the some of the defendants, man. I am for appearing for some of the defendants, man.
Okay.
But he is not the applicant of this GM, my lord.
9B. He is not 9B.
No,
No,
he is.
no, I am not 9B, man. I am
Okay.
grateful.
I'm grateful.
Item number 3.
My lord, I am appearing for the respondent. I am appearing for the intervener applicant. By affidavit of service, I am running affidavit of service.
You are for?
My lord, I am for the respondent and the applicant in GA8. GA8 is not appearing in the list. GA8 is my application.
It is you. নোটিশ অফ মোশন G8 এর কেন? এটা কি পাঠিয়েছে? নোটিশ অফ মোশনটা G8 এটা নয়? ও
The applicant intervener is the actual tenant of the shop. He has been inducted by the joint receivers appointed by the Honorable Court. Now, he has been paying the rent since August, my lord, 2021. My learned friend's client, they have trespassed into that property and they are not allowing my client to enjoy that property. They came before this Honorable Court. My learned friend's client came this Honorable Court and got an injunction, status quo, as on that. And in the status quo order, it was clearly mentioned that till it is vacated, it will continue. So, my lord, I have come before your lordship with all my papers to show that I am the bona fide tenant of that shop room, and I am praying that leave may be granted to intervene me in this matter, and my lord, to vacate the status quo order in respect of this particular suit.
এটা G8 এর সাথে এটাকে লিস্ট করুন।
My lord, I have annexed all my rent receipts, annexed A9 on the, and the affidavit I have
List
given
this matter
to-
along with GA.
But I'm appearing for the respondent in this matter. I would like to file a affidavit
Mr.
in
So and so,
opposition.
learned advocate. আচ্ছা তার আগে কোনো this is an application for vacating and or modifying order dated 20th April 2022 passed in I number GA8 of 2022 in CS number 390 of 1978. Mr. So and so, learned advocate appearing for the respondent 625. Respond number?
I'm the applicant in GA.
In this application, your respondent number?
Been made applicant in this application. But I'm being served with a copy of this application.
You are not a respondent in this application.
Respondent in this application. He was also my lord intervened.
ওটা আসুক। Let that application be listed along with this. You'll find out.
There are only one indulgence, my lord. I'm another intervener, GA12. My lord, it was directed to appear on 11th June. It is also not appearing, my lord. May it be listed any day. Alone. Grateful, my lord.
List this matter along with GA8 of 2022 and GA12 of
2024.
2024.
But I'm the defendant number 1.
No.
Can I appear for?
Item number 4. Item number 3.
Five or 41. My lord, I made my submissions on the last. Made my submissions on the last occasion. My lord, my argument mainly, my lord, centered around that, my lord, the suit is, my lord, of 18th, my lord, 1872. And my lord, the court itself, my lord, I refer to, my lord, lordship may kindly recollect the order passed by Honorable Justice Devangshu Bosak. My lord, raising doubts about, my lord, there were certain queries. My lord, if your lordship so pleases, my lord, I can again refer it to, my lord, that the suit may not be surviving. That is, at page 27. The order dated 22nd January 2021. My lord has been pleased to get that. Says that landed advocate appearing for the petitioner submits that the petitioner appointed as a trustee by an order of the court. There is a scheme framed by this honorable court in this suit. By virtue of such order, the trustee is appointed. The trustee requires directions as per it for hearing. On a query from the court as to whether the petitioner served a copy of the present petition upon the parties interested, learned advocate appearing for the petitioner submits that this application need not be served on any of the parties to the suit. On further query from the court, it was query from the court as to who are the parties to the suit and whether they are alive or not, because it is a suit of 1872 or not. Learned advocate appearing for the petitioner submits that parties to the suit as appearing in the cause title may be dead. However, since the petitioner is applying pursuant to an order of the court appointing him as a trustee, the petitioner did not take suitable steps for the purpose of amendment of the cause title or have the application served upon the persons having interest through the original parties to the suit. Learned advocate appearing for the persons claiming to be the Sebaid submits that there are various applications pending. He seeks directions for affidavit. There are very many issues which are raised in these proceedings. Apparently, a suit being CS number such and such, this is the present suit, was filed before this honorable court. The first issue is with regard to the cause title. Apparently, the petition is intitulated. The same does not reflect in the cause title of the plaintiff. The next issue is of the litigants to the lease being alive or not. In such circumstances, without prejudice to the rights and contentions of the parties, it would be appropriate to permit the parties to file affidavits. Let the affidavit in opposition be filed within 4 weeks from the date. Reply thereto, if any, then the direction of the affidavit. So, those were the queries from the court. Now, in that application, we appeared. Now, the direction for affidavits were given. But what happened, later on, instead of pursuing this application, this application was made not pressed. Behind our back, we are not aware of. And a further application was moved, wherein the orders were passed, that was also not served on us. The persons, who intervened before Honorable Justice Bosak. Now, that order passed, in the subsequent application. In the prayer portion, really that order has been, it seems, that we are aggrieved of and, the prayers are made. But, if your lordship kindly look into, the body of the petition. This is only for the purpose of recap. If your lordship kindly comes to, paragraph of my application, this application. Paragraph 6. I have taken up that pleading, made that pleading.
Yes.
Then 7. Conduct of the parties. 8.
Yes.
Now, I'll refer to the prayer, at a later part. I argued before your lordship, lordship may kindly recollect that, my main sphere of argument was, what is the nature of the suit today? What really, we are, with before your lordship? On what basis? It's a suit of 1872. I it should be, my lord, once the applications are there, my lord, the original paper should be before your lordship. I do not know, my lord, whether those have come of that 1872 suit. My lord, it has been called to be an administrative suit or suit for administration of an estate. Now, my lord, for that purpose, lordship may kindly recollect, my lord, I relied on, my lord, section 92 of the CPC, my lord, section 3 of Charitable and Religious Trust Act, because, my lord, it's a Devottar ultimately. And, my lord, at the same time, my lord, chapter 10 of the original side rules, my lord, that within this scope, my lord, only, because we need to have a, my lord, it is to be backed by law. My lord, the suit that is we are before your lordship. Or, my lord, it is to be by way of a, in case of a trust property, my lord, we all know, by way of a originating summons. My lord, it is admitted, my lord, as on the face of the record, it's not a originating summons suit.
You say that GA 29 of 21 was withdrawn without information to your client.
Mine.
Huh? But the day on which this query was raised by the court, one Mr. Roybot Banerjee was representing the petitioner and Mr. Choyan Gupta for the respondents.
Lord, yes.
The order in which the court records dismissal as withdrawn also records that some of the reservoirs were represented.
Well,
and Mr. Choyan Gupta name is also recorded. So the advocates who appeared on the date the query was raised and the advocates who appeared on the date it was withdrawn was well within knowledge of the respondents.
My lord, I am grateful, my lord, lordship has raised this query, my lord, it has fallen from your lordship. My lord, that is one of our specific allegation. My lord, here, my lord, the persons, my lord, who is of choice, who is in league with, my lord, if your lordship kindly permits me to say so, with the petitioner, my lord, there, in that petition, my lord, only they were informed. We were not being represented by Choyan Gupta. That is one of specific grievance of our, my lord, in this application. And, my lord, we have alleged collusion. My lord, this is, my lord, our submission, my lord, of the collusion. But in any event, my lord, my lord, subsequent, I found, my lord, subsequent applications were moved before Honorable Justice Saraf. My lord, a scope of that application, my lord, there it was taken up by Justice Saraf, my lord, it was taken up in detail. My lord, the application of similar nature, my lord, was disposed of. So, my lord, I really didn't harp for, my lord, recalling of that order. My lord, though the prayer is there. My lord, I really harp for, my lord, seeking, my lord, my answer to the queries of the court itself, my lord, which they tried to give a go by. My lord, that's why, my lord, on the last occasion when I made my submission, my lord, I referred to the order of Honorable Justice Bosak. My lord, today, in which proceeding, my lord, we are before your lordship. Now, what is the nature of the suit? Under which provision of law? Today we are being guided.
But then that is not trade.
My lord, that was the issue, my lord, I am supposed to answer today. My lord, I ended my argument on the last occasion with two propositions. One, my lord, so far suit relating to trust for the purpose of administration, my lord, I referred to the sections. That either of these sections, my lord, this suit has to be guided either by section 92 or by section 3. My lord, if your lordship may kindly recollect. Now, my lord, I said on that occasion that, my lord, I'll be relying on judgment on this. This is one aspect. The other, my lord, I argued at that point of time, the purpose of coming back today before your lordship. Otherwise, my lord, my learned friend would have started. My lord, that there has to have a conclusion of the proceeding. My lord, if a suit for administration is filed, my lord, if that issue before your lordship in that suit is answered, my lord, that suit ends there. That application ends there. Now, my lord, the moment it ends, my lord, the proper process should be a fresh application before your lordship, relying on, my lord, those legal provisions, either section 92 or section 3 or, my lord, originating by way of originating summons. Now, my lord, in that case also I submitted, my lord, that court cannot pass an order, my lord, which requires a continuous surveillance. Lordship may kindly recollect. Now, my lord, that part of the argument, my lord, I'll be saying, my lord, the just now that I have submitted, my lord, in case of trust, we may need to come back before your lordship on repeated occasions. It's not that, my lord, it ends, my lord, in one occasion. So, my lord, I modify my that submission to the extent that, my lord, the moment I approach before your lordship, my lord, that query is satisfied. My lord, the matter ends there. I need to come up with a fresh application. It cannot be an 1872 suit. My lord, that continues. And what was the scope of that suit? I don't think, my lord, even my learned friends are really aware of the real scope of the suit. Now, my lord, for that purpose, my lord, if your lordship kindly permits me, my lord, I'll be relying on, apart from the sections, my lord, I have relied on. This is, my lord, an old decision. My lord, I have brought, my lord, of Gujarat High Court judgment. My lord, because of the fact, my lord, so far our High Court judgments are older than that. My lord, all have been taken into consideration in this one. That's why, my lord, those have been quoted. So for the administration, the suit for administration, its scope and the concept of administration suit, apart from, my lord, the definitions that I already have placed before you. My lord, this is AIR 1964 Gujarat, my lord, page 174. Paragraph 3 to paragraph 8. The rest of the paragraph deals with, my lord, point of limitation and others. My lord, the relevant paragraph, the part, my lord, which deals with, my lord, the concept of administration. My lord, in that first page itself, my lord, paragraph 3. 3 clause 1. The suit for administration does not lie because there was also a prayer to hold sale deed executed by the deceased in the name of his wife, no, my lord. It is contended, my lord, these are the contentions. My lord kindly comes to then straightway to, my lord, paragraph 4. My lord, paragraph 4 in the next page. My lord, may I place the relevant portion?
Yes.
The nature and scope of, the last sentence of the paragraph 4 and onwards. The nature and scope of administration suit have been discussed in various reported cases in annual practice for 1860. At page, my lord, the references have been given, my lord. These are really, my lord, the law of England, my lord, those have been quoted at that point of time, is quoted as follows. The executors or administrators of a deceased person or any of them and the trustees under any deed or instrument or any of them or any person claiming to be interested in the relief sought as creditor, devicee, legatee, next of kin, or heir at law, or customary heir of a deceased person, or as sestuique trust, under the trust of any deed or instrument, or as claiming by assignment or otherwise under any such creditor or other person as aforesaid, may take out, as of course, an originating sum. Not lordship may, not as I was submitting, returnable in the chambers of a judge of the Chancery's division for such relief of the nature of kind following, as may by the summons be specified and as the circumstances of the case may require, that is to say, the determination without an administration of the estate or trust, without an administration of the estate or trust, of any of the following questions or matters. This is one. Then sub-rule G of this rule provides that any question arising in the administration of the estate or trust can be determined. In Shiva Prasad Singh, Milord, our High Court's judgment, this is very oft quoted judgment, Milord, of 1961. 61 Calcutta, ILR, Milord, Indian Law Reports. Then, Milord, nature of suit for administration is discussed and the following observations are made. Administration means the management of the estate of a deceased person who has left no executor. The object of an administration suit is to have the estate administered under a decree of the court. In such a suit, the whole administration and the settlement of the estate are assumed by the court. The suit in its essence is one for an account and for application of the estate of the deceased for the satisfaction of the dues of all the creditors and for the benefit of all others who are entitled. And the court marshals the assets and makes such a decree. So, my lord, the purpose of the suit, court takes up the administration of the estate of the deceased for the purpose of meting out the dues of the creditors and, my lord, for accounts. It's not for, my lord, day-to-day administration of a trust. My lord, the moment that obligation of meeting, my lord, the creditors' dues and, my lord, the accounts, my lord, the very purpose of the administration suit ends. My lord, then the administration consists, generally speaking, in payment of the funeral expenses because, my lord, the person didn't have an executor of the deceased, in the payment of debts and legacies, and in collection, realization, preservation, and distribution of the assets. Forms of plaintiff in such suits are given in Schedule 1. My lord, these are with regard to the procedures. Rule 13, Order 20, Rule 13 of the Civil Procedure Code provides that in an administration suit, the court shall pass a preliminary decree before passing the final decree, directing accounts to be taken and inquiries to be made. Forms for preliminary decree are given in the Appendix D, forms number 17 and 19, and forms for final decree are given in Appendix D, forms 18 and 20. These are, my lord, so for the procedural part boards. For the purpose of, my lord, meting out the debts, for, my lord, funeral expenses, and, my lord, for my lord, collection, realization, preservation, and distribution of the assets. And, my lord, the procedure prescribes, my lord, the forms prescribed, my lord, for a preliminary decree, and, my lord, then the final decree. So it culminates, it has to culminate in a final decree, and, my lord, the matter ends there. It cannot be unending. My lord, the same concept continues, my lord, particularly if your lordship kindly looks at that portion, my lord, AIR 50 Lahore 12 written there, my lord, in the next paragraph. AIR 1950 LAH 12.
Yes.
My lord, then thereafter, it is observed that the objects of an administration suit would appear to be A. Ascertainment of debts due by the deceased, ascertainment of legacies directed by we testator to be paid out. In that case, my lord, there was a will to be paid out of the estate of the estate, payment of deceased funeral and testamentary expenses, and an inquiry as to what movable property was left by the deceased and which had come to the hands of the defendant or any other person by his order or for his use. An inquiry as to what part of the movable property of the deceased was outstanding undisposed of. An inquiry and an account or what, if any, was the plaintiff entitled to as next of kin of the intestate. My lord, nowhere, my lord, the purpose of placing, my lord, these portions, that, my lord, procedure otherwise available to us, Lord, I already have placed before your lordship, my lord, so far the statute goes. My lord, so far the nature of an administration suit, as we submit before your lordship, before the honorable court, my lord, this judgment has dealt with, my lord, the judgments. Those, my lord, has described this, my lord, the administration, suit for administration. And it explains, my lord, that the purpose is, my lord, where a person is dying, my lord, where there is no executor. And, my lord, for the purpose of paying debts, funeral expenses, my lord, it's not an unending affair since 1872. You know, this is, my lord, it goes on, my lord, on the similar nature. My lord, the last part, if your lordship kindly looks at, the same thing, my lord, those have been repeated in various judgments, those have been quoted. I will not, my lord, put your lordship to botheration by repeating the things. If your lordship kindly look at, my lord, paragraph 7 and paragraph 8. My lord, two of the judgments, those have been taken into consideration. Abdul Rahim versus Lingappa v. Bhaijappa, my lord, 45 Bombay law reports. The same thing. An administration suit is in essence of a suit for an account. My lord, kindly see this. My lord, the Bombay High Court that has been dealt with. An application of the estate of a deceased debtor for the satisfaction of the dues to all his creditors. The entire administration and settlement of the estate are assumed by the court. Settlement of the estate. The assets are marshaled and a decree is made for the benefit of all creditors. Well, the same thing. But if there is outstanding, that is to be paid out of the estate of the deceased. Where, my lord, there is no other administrator. The court is taking up, my lord, for the purpose, taking up the responsibility as a, my lord, for the accounts and paying, my lord, the debts of the deceased. My lord, if I am correct to say so. My lord, the 8, same thing. My lord, this is Madras High Court judgment. Amir Bai versus Abdul Rahim. 28 matters that has been quoted. Administration means management of the deceased estate. The court is requested to assume its management, to take upon itself the functions of an executor or administrator. An administrator and administer the estate. The administration of a deceased estate consists of collection and preservation of assets, payment, debts and legacies. Acts in respect of adverse claims to assets, dealing with creditors or legatees, and distribution finally amongst the heirs or next of kin. But the same concept. So, Mullah, today, merely, my lord, coming before the court, claiming to be an administration suit. And, my lord, in the garb of, my lord, this administration suit, my lord, taking out applications one after the another, my lord, for decades together, for keeping control over, my lord, the management of, my lord, temple, my lord, which is otherwise very important, my lord, in our society. My lord, we say, my lord, that application, my lord, the query, those who are falling from the court itself, my lord, it had to be answered. Now, my lord, one contention that may come in anticipation, I am saying, my lord, as it has also fallen from your lordship, my lord, so for the prayers. My lord, in my pleading, the contentions are there. Prayers, my lord, it's really, my lord, not in the fashion or in the manner, my lord, I am submitting before your lordship. Pleadings, my lord, those are there. My lord, in that case, my lord, lordship may kindly allow me to, my lord, rely on the judgments, my lord, wherein the court has, my lord, the discretion for the delivery of substantial justice, my lord, the final justice, for ends of justice, my lord, for molding the relief. Because, my lord, the parties knew, my lord, parties are before your lordship, my lord, we are arguing the things before your lordship, knowing, my lord, what is there in the pleading. My lord, lordship knows, my lord, the issue may not be framed, but parties knew the issue, went into trial, the materials were there, my lord, those were relied on and, my lord, argued. Then in that case, my lord, irrespective of, my lord, whether the prayer has been made or not, whether the issue is framed or not, my lord, only those nature of judgments, my lord, 3 judgments I will be placing before your lordship. Very much. My lord, this is, let me give, my lord, the older one first, then, my lord, I will give your lordship, my lord, the recent ones. My lord, one is, my lord, of AIR 66 Supreme Court 735. My lord, the relevant para is paragraph 10. My lord, kindly sees this. Take to the outside.
Yes.
My lord, the para 10, page 3. I mean, my lord, internal page 3. My lord, this is not, my lord, Xerox of the book. The reference is given there. My lord,
My lord,
lordship
10.
kindly.
10 you are referring? Para 10.
Para 10. Para 10, my lord, the last 3 line in that page, my lord, the general rule, no doubt. My lord has been pleased to get that. The general rule, no doubt, yes, from there, is that the relief should be founded on pleading made by the parties. You know, our pleading is there, relief is not. But where a substantial matters relating to the title of both the parties to the suit are touched, though indirectly or even obscurely in issue, and evidence has been laid about them, then the argument that a particular matter was not expressly taken in pleading would be purely formal and technical and cannot succeed in every case. What the court has to consider in dealing with such objection: did the parties know that the matter in question was involved in the trial? In our case, my lord, in this application. The parties are aware of, my lord, our pleading. We have pleaded, my lord, about the order passed by Honorable Justice Bosak. We have pleaded about, my lord, ex parte, my lord, not pressing of the application, withdrawal of the same. And at the same time, my lord, our allegation of collusion and, my lord, obtaining an order, my lord, wherein we were not served. So, my lord, those pleadings are there. Prayer, my lord, that's why, my lord, this judgment. Prayer, my lord, it's, my lord, really not written in that word. That the matter in question was involved in the trial, and did they lead evidence about it? My lord, in our case, only pleading. If it appears that the parties did not know that the matter was in issue at the trial and one of them had no opportunity to lead evidence in this way, that undoubtedly would be a different matter. That is not the case here. But they have dealt with it in affidavit. To allow one party to rely upon a matter in respect of which the other party didn't lead evidence, this part doesn't apply. And had no opportunity to lead evidence would introduce considerations of prejudice. And in doing justice to one party, court cannot do injustice to another. So, my lord, that situation is not prevailing here. They have dealt with, my lord, our allegation, my lord, in their opposition. So, my lord, considering the issue that is being harped, my lord, we are arguing the things before your lordship, and we have annexed our relevant papers to our application, which are, my lord, otherwise not disputed. So, for the records are concerned, my lord, not disputed. Then, my lord, that was 1966. My lord, this is, my lord, of 75. My lord, AIR 1975 Supreme Court 1409.
Give the copy.
This one. I have opened that page, my lord, really page 4, internal page 4. The last paragraph.
Yes.
My lord will get, my lord, from the middle. It is basic to our processual jurisprudence from there. it is basic to our processual jurisprudence that the right to relief must be judged to exist as on the date of the institution. This is with regard to the limitation the court has really. Equally clear is the principle that procedure is handmaid and not mistress. These are very oft quoted. If a fact arising after the lease has come to court and has a fundamental impact on the right to relief for the manner of molding it is brought diligently to the notice of the tribunal, it cannot blink at it or be blind to the events which stultify or render inept the decretal remedy. Equity justifies bending the rules of procedure where no specific provision or fair play is violated, with a view to promote substantial justice, not as I was submitting, for the purpose of substantial justice. Subject, of course, to the absence of other disentitling actors or just circumstances, then these are the disqualifying aspect of. Nor can we contemplate any limitation on this power to take note of updated facts to confine it to the trial. At this point. But my point is of molding the relief by the court. It can be molded. If the pleadings are there, then the nearer one, this is AIR 2009 Supreme Court 1103. The relevant paras will be 11 to 12. এটা হচ্ছে AIR 2009 Supreme Court 1103. Paragraph 11 and 12. এটা to the it says, the High Court has ignored the aforesaid principles relating to the object and necessity of pleadings. My Lord has got that. Even though right of easement was not pleaded or claimed by the plaintiffs, and even though parties were at issue only in regard to the title and possession, it made out for the first time in the second appeal a case of easement granted relief based on it. For this purpose, it relied upon the following observations of the court. Then the judgment of 1963 has been quoted. No doubt, no issue was framed, and one which was framed could have been more elaborate. But since the parties went to trial, the same thing, same principle, only different language, the same principle. The various judgments have been quoted, the same thing has been repeated. All these judgments starting from 1963-66. I already have placed before you. 12, is the conclusion of that judgment. It is thus clear that a case not specifically pleaded can be considered by the court only where the pleadings in substance, though not in specific terms, contains necessary averments to make out a particular case, and the issues framed also generally cover the question involved, and the parties proceed on the basis that such case was at issue and had laid evidence there. So, my Lord.
Yes. Yes.
My Lord, my argument, my Lord, I have sought for, my Lord, relying on the pleading. My Lord, really today, because, my Lord, for 2 years or 3 years, my Lord, they are framing, my Lord, the schemes, and, my Lord, then again a further election. But this is a process, my Lord, that is being continued. In that sense, my Lord, the recall of the order that we have sought for, I found, my Lord, Honorable Justice Saraf has dealt with it one such application, my Lord, of recall. And in any event, my Lord, those period is more or less over. My Lord, on the last occasion also, I submitted. My Lord, that's why I restricted myself. Instead of, my Lord, bothering your Lordship, my Lord, wasting your Lordship's time, my Lord, of that, my Lord, part of the election. That, my Lord, today we need to, my Lord, as it is also inquired by the court also, that, my Lord, what is the fate of this suit? And, my Lord, under today's prevailing law, as it is. It is a suit of 1872. My lord, probably, if I am not correct, my lord, if your lordship will correct me, my lord, CPC 1908, prior to that, my lord, 1849 or 59. My lord, at that point of time, it is guided under that law. And my lord, there, my lord, probably certain orders are passed. We do not even know, my lord, what the cause papers are. Because Honorable Justice Bosak's orders say that, my lord, even the original cause title, so for their applications even, are not appearing. That's why, my lord, that point of intitulated, my lord, cause title has been, my lord, observed there. Now, my lord, to get rid of that, my lord, I submitted before your lordship, my lord, that I may be permitted to say so a classic example of forum shopping. Now, my lord, that was done. Now, my lord, that's why, my lord, I restricted my submission to that extent. The queries, my lord, those are there by the court. My lord, let those be answered. That, my lord, whether today we are guided, should we consider this to be a suit under section 92 of CPC or, my lord, section 3? Only that, my lord, that observation and, my lord, the order of the court, my lord, we are seeking today.
We suppose the suit, as you say, 1872 is not in existence. Now we come to you have referred the judgment. See, how do you preserve the assets of the estate?
Lord, in that case,
because the principles which you have laid down, like right now laid down by the different judgments, it says that it consists of collection, preservation of assets. How the preservation of assets of the DT, or the trust, is to be made?
my lord, two things. If your lordship kindly,
you have submitted that once the suit comes to an end, so there cannot be continuing process.
No.
This is your submission.
Yes.
But how do you preserve the property?
my lord, for that purpose, my lord, the persons who will be at helm of affairs, my lord, in this case, my lord, the Orponnama or the deed of trust, whatever is there, or at the time of, if that suit is decreed, my lord, I do not know. If the decree mentions, my lord, a procedure that wherein a person, my lord, was vested with, my lord, the management of the trust or, my lord, the estate, my lord, it will be responsibility of the trustee or the Sebite or, my lord, whoever is interested in the outcome or management of the trust to approach before your lordship, my lord, under the provision of law, my lord, those have been provided.
Then that application has been made.
That's my case, my lord. That's what, my lord, I submitted before.
No, no.
May I
They
repeat
have
that?
also come up with an application. So what is the?
No, not so. My lord, yes, my lord, kindly once. My lord, may I? My lord, in case of 92. My lord, as we know, usually, my lord, if we deal with a normal trust, then, my lord, section 34. My lord, in this case, this is not an usual trust. If it is a trust at all, there is a deed of trust. Then, my lord, the Indian Trust Act section 34 will not apply. If not, my lord, the Official Trustees Act, or, my lord, any asset or estate of the trust is lying with, or the management lying with, my lord, the official trustees. Then in that case, my lord, Official Trustees Act and, my lord, our Indian Trust Act, my lord, section 34 we will. Otherwise, my lord, in my respectful submission, the relevant provisions will be, my lord, section 92 either. My lord, lordship kindly sees. In case of any alleged breach of any express or constructive trust created for purpose of for public purpose of a charitable or religious nature, or where the direction of the court is, that's why I said that by which direction that was disposed of, direction of the court is deemed necessary for the administration of any such trust, the Advocate General or two or more persons having an interest in the trust and having obtained the leave of the court may institute a suit. Lord, it has to be by way of, my lord, under section 92, by instituting a suit, whether contentious or not, in the principal civil court of original jurisdiction or in any other court empowered in that behalf by the state government within the local limits of whose jurisdiction the whole or any part of the subject matter of the trust is situated, to obtain a decree. Then, my lord, it has been given, removing any trustee, appointing new trustee, vesting any property in a trustee, directing a trustee who has been removed, who has been ceased to be a trustee, to deliver possession of any trust property in his possession, directing accounts and inquiries, declaring what proportion of the trust property or the interest therein shall be allocated to any particular object of the trust, authorizing the whole or any part of the trust property, then, my lord, settling a scheme. As, my lord, my learned friends are repeatedly, my lord, relying on that scheme, that it has to be either by this section 92, by instituting a suit, not by way of an application in a, my lord, disposed of a dead suit. That's what I am trying to, my lord, ascertain today. Even the court, my lord, was confused. Now, my lord, that is the procedure. It's not by way of a GA. Granting such further or other relief, my lord, I do not know, my lord, whether they
Trust Act.
Now, my lord, Charitable and Religious Trust Act, 1920. Granting such further or other, my lord, so far this is 92 goes. My lord, may I read out and hand over? My lord, I have got a copy, my lord. Section 3. Power to apply to court in respect of trust of a charitable or religious nature. Save as hereinafter provided in this act, any person having an interest in any express or constructive trust created or existing for public purpose of a charitable or religious nature may apply by petition to the court within the local limits of whose jurisdiction, any same 92, only little difference, jurisdiction, any substantial part of the subject matter of the trust is situated, to obtain an order embodying all or any of the following directions, namely, my lord, directing the trustees to furnish the petitioner through the court with particulars as to the nature and object of the trust, and of the value, condition, management, and application of the subject matter of the trust, and of income belonging thereto, or as to any of these matters. And then, directing the accounts of the trust shall examine and audit it, provided that no person shall apply for such direction in respect of accounts related to period more than 3 years. My lord, this is the other procedure.
Yes. That's all.
My lord, that's, my lord, because those are my submissions on the last occasion on this premise.
Yes.
My lord, I am arguing before your lordship, my lord, GA 35.
Yes.
GA 35.
41 is also. 41.
41 is your application.
My land friend does not make any permission.
41.
41, they have filed their opposition. Mr. Ghosh, you have filed your opposition to 41?
My lord, their opposition, my lord, my reply. My lord, reply probably.
No, in 41, their application, you have.
35 and 41.
Oh, your application. And that application for holding election, that is for 42. So you will be, what is 41?
41, same fact, because fact cannot be different, same pleading. Only, my lord, there is little difference in prayers. My lord, prayer, my lord, my lord will find, my lord, first prayer is same in all the applications with short cause title. Then, my lord, condone the delay, my lord, of 18 days. Then, my lord, recall of that judgment by Honorable Justice Sarah. My lord, that was in our absence. And I think, my lord, the second A, or rather, my lord, this is the third A. My lord, I should, my lord, lordship kindly.
Third A.
There are 3 A's, my lord, the third A, my lord, in J number 30. My lord, this is, my lord, somewhat, my lord, if I argue this, my lord, this third A, my lord, then I'll have to rely on a further judgment. But, my lord, today I don't want to do that because, my lord, that is with regard to, my lord, administration of another famous temple, my lord, of Kalighat. My lord, wherein there a scheme, my lord, on a public interest litigation has been framed by this honorable court. My lord, wherein public is having an access, my lord, public funds are being invested for the infrastructure, and, my lord, a detailed scheme has been given. My lord, probably such type of matter is pending, and that's why, my lord, that prayer of third A is made before your lordship. My lord, there is a public interest litigation relating to of the same nature is pending. But, my lord, right now, my lord, I don't want to, my lord. Lordship kindly, my lord, deal with my submissions in both the applications what I have made. That the nature of the suit, my lord, under which provision out of 92 and 3, my lord, or if my learned friend says, my lord, there is any other provision.
So you restrict your submissions with regard to 35 and 41 as to the queries raised by the court?
Mainly,
that is
to be answered.
In 35 and 41, same. Okay.
The nature of the suit.
But the sum and substance of what I can understand is entire grievances that Justice Boshak had passed an order in an application which was subsequently withdrawn. This is a point which is not being raised for the first time. This point was agitated before this, and this court has already gone into this issue, has discussed this thing at length, and has delivered a judgment. That was not placed for your lordship.
Okay.
That judgment, no appeal has been preferred. So that judgment has reached its finality. So when a judgment reaches its finality, that people for further application, I ask myself this question. The same points.
You have annexed that.
Right. Today we don't have much time. I'm just 5 minutes. That's why I'll just give you lordship, and that judgment is there. Lordship wants to.
Okay, you come up on next date, you place the entirety.
Yes. Because I'll tell you, lordship. So this entire argument made by my learned friend, futile attempt. I'm sorry to say this. And I will say that the mischievous intent is the learned advocate appearing both then and now. Same. So it's not a question of there being any ignorance. No, I don't like this interruption. No, my lord, this is not fair. This is not fair, my lord. Then let them finish their submission and make
That matter when he is putting in this way, therefore that it was placed before Honorable Justice Sarah That violation got ordered.
I'm not hearing you.
Yeah. But in 41
Yes.
also I am there. He is telling,
Yes.
and in 41 I have right to say, I have not stated as my junior brother has stated. But ultimately,
If Mr. Sudeep Ghosh has made his submissions with regard to 35 and 41, and that is 35, sir, please. 35 and 41, he concludes his argument, you take your seat.
he concluded his argument regarding another point, but the
No,
regarding
this
the
cannot go on like this.
actual
You are sitting and rising and you're making your submissions. I cannot follow that. I have asked Mr. Sudeep Ghosh whether he has concluded or not. He says that yes. No. Mr. Sudeep Ghosh has made his submissions on behalf of the applicant in 35 and 41. Please take your seat. I am not hearing you. I am not hearing you. Mr. Sudeep Ghosh has made his submissions. No, please take your seat. This is not the way. No. Yes. Please.
But I can't get into these sort of wells. I have crossed too many years now. I cannot. Coming back to what I was saying. So, my lord, when a point, may I just give you a bit of the background? I shall take you to the papers at a later stage, my lord, because right now we don't have time, my lord, I have not got the lecture. It's the suit for 1870. The suit lays down a particular scope of administration for running, day-to-day running of the Doksheshwar temple.
Yes.
And this day-to-day running continues from 1872 to this day. There is not even a single day which has happened when the administrative suits orders have not been implemented. It's a day-to-day running. A scheme is running.
Yes.
And possibly, blood, if one sees that possibly the temple trust is run so well because it is under the direct monitoring of your lordships. Every time the trustees have to come, apply to your lordships for conducting of election. Your lordships appoint a special officer to conduct the entire elections. Your lordships look at the entire process of conducting. Your lordships confirm the order. Lordships also direct filing of accounts, everything.
Yes.
And the only reason why the temple is maintained the way it is that because there's such close supervision by your lordships.
Yes.
Nobody can today treat its temple as their personal fiefdom. And that there is a proper election that is conducted every time. Lord, last occasion, it was conducted by none other than former Chief Justice of this court, Justice Jyotirmoy Bhattacharya. He personally, from early morning till way past midnight, conducted the entire process very, very meticulously. I shall show to your Lordship his report. Your Lordship will find every point has been taken into consideration by him in his report as far as conducting of the election. Extremely meticulous. He did not leave even a half an inch to anybody else. Everything done by him. That is the manner in which elections are conducted and the temple is conducted. And we see it bearing fruit from the fact that it is one of the finest temples in the country. And this is not at all a public trust. Neither the government of India, not the state government pays any money to this temple.
Sure. Stop here. Next. Mr. Sudeep Ghosh, learned advocate for applicant in GA 35 and 35 of 22 and 41 of 23. ठीक है? Who concludes his argument. Mr. Amitesh Banerjee, learned senior advocate, appearing for the respondents. Due to paucity of light, is very good not to contribute. Honorable, next week. Tuesday. Tuesday. Okay. Get any one. Happy. Wednesday or Thursday. Thursday they will Thursday no, not Thursday, Wednesday.
Then the week thereafter.
Excepting Monday, you are not here in.
The rest of that week I'm not there.
Then on Monday
The
week.
Monday or Monday week?
Yes. 18th.
Yes. 18th.
18th they can in 18th. 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 Nineteenth.
19th. Not sure. 18th, Milord, it's all right. 19th, I got Milord to appeal to matters fixed.
28th. Wednesday.
Wednesday. Let
No, either 18th, we have, let us do our arguments on 18th, then not after we'll fix some argument.
18th.
18th another problem is.
Oh, Lordship is
My lord.
19th.
19th.
I want to fix the
19th,
matter so that you can have time to
Yes.
argue and
Then
you also can reply.
19th.
19th.
19th, Milord, I have
What
to
you do,
regard
you
this, Milord.
ask your junior to remain present, let him argue and make his
Then, Milord,
conclusion. If you
other-
intend to make any reply, you'll fix a date for reply.
Fine, fine.
For 19th. Thank you.
Good job.